To all of y'all, and I welcome y'all to today's marathon. Today's marathon we will be taking is about your CRVI for CS professional, and yes, the new syllabus will be covered. I am your professor Zubair Jahangir. Let me give you a brief introduction about me of who I am and why I will be taking your sessions. Just before I start, can I have in the chat box whether I'm audible and visible quickly so I can continue with my marathon. Now I have taught at the ICSI, I have taught at the Indian Institute of Corporate Affairs, I have taught for the Bombay Stock Exchange, okay, and I have a few businesses as well, okay. And one is a few gifts for all of y'all. Is first is the scanner, the JT scanners, where all the past exam questions and the ICSI model solutions is given to you. Now with that you can easily see what kind of questions are asking and what answers are they expecting from you. You can get it on our website in the free study material sections. Over 2,500 students have already downloaded and studied from the scanner, so you can do it too. And another gift that we have given to all the students is the Dream Badge. The Dream Badge gives you access to all the paid lectures. Yes, all the paid lectures in depth you can get for a nominal amount of $299. However, this is a limited period offer and it will only be valid till your examination. So you can go ahead, enroll, see the study, see the methodology of teaching, and you will realize it is completely, with a different standard altogether. It gives you unlimited views and you can view it on the phone as the and the mobile as well. Okay. Now, having said that, let's begin with today's marathon. Okay. Now, let me tell you what is the strategy for today. Before I start, I want you to hit the like button, share it with your friends, sit in a separate corner and give me your time. As long as I'm taking the marathon, I will cover the most important things from your examination, and when I take up few things, I will be covering in depth. Now let's see for your entire corporate restructuring. Okay. Now, what is the plan for today? Pay attention. Now, the corporate restructuring part A comes for 40 marks. How many chapters do you have? You have around 11 chapters for 40 marks. Too many chapters for 40 marks. If you go to your part C, again from 14 till 27 or 26, okay, 26, 27, 26 chapters, you have 40 marks again. So many chapters to fetch you only 40 marks in part A and part C. Whereas you see one hack that ICSI has given you. One small little thing. Have you all seen what it is there or no? So now, no matter what you're doing during your exam time and right now, the most important thing for you is to score maximum from here. So only two chapters and you get 20 marks. See, in your part A also you can attempt, considering it has a few sub things that you studied from your executive. Even in your part C you can write it, but valuation is something completely new for you all. Okay. So sir, what's the plan? What are we planning to do today? Okay. So first thing is, as we saw that 11 chapters for 40 marks, too many chapters to get 40 marks. We are going to first cover the entire 20 marks. So 20 marks we will cover entirely. So if you have not done valuation before, hit the like button. It is going to be an amazing session for you. And even if you've done it before, it is going to be a fast-paced lecture. So I will cover both the chapters right now in the very beginning in front of your eyes, including the past exam questions. So 20 marks will be covered right now. Clear till here? Everyone. Till the next thing that we will be doing is when you see your insolvency subject, okay, your insolvency part, that you feel that it is for 40 marks, right? Your insolvency will mostly cover your Insolvency Bankruptcy Act 2016. You feel that it is for 40 marks, right? However, I have told you all to take the insolvency subject, and if you're taking the insolvency subject, this entire part becomes 140 marks. Now, what is the problem is that some sections are here, some sections are here, some sections are here, some sections will come here, and it's not even given in order. So, and obviously, when you're studying for your open book and your closed book, you need to know one act thoroughly, that is your IBC code 2016. So, in my second part of my marathon, so in the first part, we will complete valuation, both the chapters, 20 marks. In the second part, I will cover your IBC code from the Bare Act. And I have prepared one beautiful presentation for you all, where the full Bare Act will be done, and all the chapters contents. I have added it, all the sections that have come in a beautiful order. So all the order sections we will be doing, and everything will get covered, not only from your but even your open book. So from the Bare Act I have covered, and these Bare Act include the latest amendments as on 2025 as well. Okay, so can I have a can I say this marathon becomes extremely important and valuable? Yes or no? In the chat box, are you all excited to start and complete with me? Okay. Now remember one more thing, that someone has asked for the sums, valuation sums. So yes, the sums Samina ma'am will be taking. That will be a separate session. Okay. Though if you want, you can directly get from our dream batch. But Samina ma'am is also gearing up for one practical sum sessions, because this full 20 marks we want in our pocket. Okay. So one sum or two sums come in the exam. So that also you need to know. So those, don't worry, we'll be covering that as well. Today we'll be covering the full chapter. The sums part is going to be done separately. So everyone good to go, yes or no? We are going to start with lesson 12 and 13 and complete this entire part. Let's begin with our lesson 12 and 13. Okay. So now we are going to start with lesson number 12, your overview of business valuation. Good to go. Can I have GTG in the chat box, everyone? So with me, open your module, complete your 20 marks with me. GTG in the chat box and we can start quickly. And if you not like the video, go ahead, like the video. It's going to be an amazing session. I want you to keep a book, pen, your modules open. Everything will be covered from the module. Okay. So all this is module. It's going to be pretty fast. I'm waiting for all of you all in the chat box. GTG. Aparna is ready. What about others? Great. Great. Good. Harsha is ready. Ananta, great. Let's begin. Okay. Chalo. From the module. Great. Thank you so much. Let's begin. I want you to be in a separate corner. In one stretch, I will start and complete the full chapter. Hi. So we'll be starting with your lesson overview of business valuations. Now remember that your overview of business valuation and lesson 13, that is your valuation of business, comes mandatory for 20 marks in your examination. So we will put our entire efforts and do it completely well. Let's begin. Overview of business valuation. Now first thing is, when one company plans to buy another company. So whenever you go to buy something, you have to fix the price. You need to find the value of it, and accordingly the money will exchange hands, and accordingly we will pay the price. So once we fix the value, then we will pay the price. Now how is value fixed? Who fixed the value? What are the valuation principles is what we will be studying in this chapter. The valuation methods, etc. A basic real life example is when Zomato acquired Blinkit for 4,447 crores. Okay. Now, when Zomato acquired Blinkit, they paid this random figure. Now, obviously, this random figure was the value of the company. Now, how was that computed? What are the aspects of it is what we will understand. Let's start. So, first thing when we start is the introduction. That the meaning of the term valuation. Now, remember that when something is pretty simple, I don't expect in an exam I will go faster. You can go faster with me. Okay. When something is important, I will stop and mark it as important. Now, very first thing is you have to remember that it is given under which chapter valuation? Chapter 17. Okay, of Companies Act. Read with your section 247. 247. Read with the valuation rules 2017. Clear? So we will be seeing. Now, what do you mean by the term valuation? So, valuation is a process of fixing the worth of a particular asset. So, it is fixing the worth of an asset. Now, obviously, it is context specific. That means valuation, the value of a person, the value of something will change from person to person. If it is a related business, maybe I might value it more, but an unrelated business might not care for it at all. Okay. Now, the valuation of businesses is done by a valuer, and a valuer is all the details of them is a registered valuer. It is given under section 247. So, sir, what is ultimately the term valuation? So, valuation is a process of determining the value of certain assets, and value is always shown in monetary terms. So, I will come to know that the value of this company is XYZ, the value of the machinery is so and so. So, it is assessing the worth of an asset. Now, while fixing the value, we look at various aspects. So, if I am fixing the value, I look at various aspects, factors. This will come later part of the chapter as well. Okay. So, whatever it is ultimately a professional judgment. Okay. So, two valuers will value two companies differently according to their past experience, according to their professional judgment, according to different methods. Different values can come up. Okay, so valuation is a professional judgment. It is not, nobody can say that this is the exact value. Another person will look at different things, different risks, different strengths, and might value it differently. There are different and multiple valuation approaches and methods. Now, always remember that valuation is expressed in terms of money. It is a financial information. Never can valuation be given not in terms of money. Okay, so it is always given in terms of money so that others would come to know that this is the value of a share, this is the value of an asset, and accordingly price will change hands. Now, coming to something that is important. So, just I'm going through, not everything is important, I'll be telling you. Okay. So, first thing is your genesis of valuation. What does the genesis of valuation mean? Just a simple thing. Again, they are repeating that valuation is a process of determining the economic worth of an asset. That what is the worth of this company. Okay. And normally valuations could be done for various purposes. For example, if I'm going to buy a particular company, so I would want to value that target company. Second, if a bank wants to give a loan to a company, they would do an assessment of the valuation of the business and then sanction the loans. If we saw Vodafone, there was a 2 billion tax case. Now again they determine the value of the company, the value of the shares, accordingly the capital gains etc. can be determined. Valuation in case of property, if a compulsory acquisition of property is done, so again we need to find the worth of that house, accordingly compensation will be given. Valuation in case of insurance can be done. So if we want to fix the premium, so if a valuation of a particular fire insurance is done, so they will have to value the assets, the buildings, the whatever it is, that this is the worth, and accordingly the insurance company will fix your premium amount. Okay. Now, remember this small little part that which I want you to quote in the exam. Okay, I want you to quote in the exam that the Rick's Red Book, okay, is there. What happened is in UK 1970 there was a crash, property crash, just like in USA in 2008 there are the subprime prices where people could not pay the mortgages, and then the entire Lehman Brothers had become bankrupt. One of their main banks had become bankrupt. So that time the Riggs Red Book and USA, they try to form certain valuation principles because all these banks ended up giving wrong loans. Anyone used to come, they used to give a loan. So now they said we should have some standard principles who you're giving a loan and how that valuation should be done. So what is Riggs Red Books? It's a UK. In UK in 1970 there was a property crash, and then the Riggs Red Book said that introduce certain valuation standards. Now this is internationally. Similarly in USA after the 2008 crisis, they also said that we should have some valuation standards. Now, coming to the need for valuation. Okay, why is valuation needed? I'm just thinking, why is valuation needed? So how will you pay the money? You will to determine the price of the product. To know the value of the product, you have to do the valuation. Once you know the value, it will come to know that how much you will pay. You shouldn't overpay or underpay. That is why it helps in your strategic decision making. So when companies are planning now, Facebook plan to acquire WhatsApp, so they will do a valuation to know whether it is strategically advisable to give or not give. When you saw same thing when Elon Musk went to buy Twitter, he made a miscalculation and ended up paying a very higher amount for Twitter. So valuation is always done by an independent valuer, by a person who is unrelated. All we will see when we do. Right now, we just have to do the headings of why valuation is done in which situations. So M&A is being done, valuation will be done, merger and amalgamation. If JV, collaboration, if ESOPs are being given, so they have to identify what is the value of the share, how much discount are we giving. Okay, whenever an investor plans to exit, he will have to find out what is the value of the company, and then accordingly he will exit. Okay, if there is operation and mismanagement in the company, then again in that case to identify whether you are having the thresholds to file a case in NCLT, then it will be done. Then comes under company law. Sometimes statutory laws only tell that they have to do, for example, private placement, or in case of sweat equity, valuation is told by law itself for laws, etc. Okay, winding up, valuation is to be done. Now, coming to factors influencing valuation. Now, this is the first thing which they have also asked in the exam. And even in the next chapter, again, they come writing factors of influencing valuation. Now, what does it mean? If I'm looking at a company, what factors affect the valuation? If a company has taken tremendous amount of loan, can I say that their valuation will drop? If a company is giving regular dividend, its valuation will increase. I'll look at I look at their past financial results. I will look at their PE ratio. I will look at their future prospects. So all these factors will be I will look at their data collection methods. I will look at various factors, and this is what we will see. So after doing a due diligence process, after studying a particular company, the next thing is to identify that we've identified this company. Now we will say let's buy it out. To buy the company, to purchase the company, we will do a valuation to fix the price. Now following things affect the market price. Okay, if a company is just supposed to come out with an IPO, so that also can affect the market price. If the company has tremendous amount of special shares, those voting rights, differential voting rights, so then again the value can drop because promoters have extra voting share. So past headings we can do, nothing concrete. We will look at your bonus track record. We will look at news. We will look at the net worth of the company, net assets, liquidity of the company. We will look at the past history of the prices, voting strength. All these factors affect the valuation, the expected rate of return, etc. Ongoing projects, etc. Okay. Now we come to one general stuff which they have told. What are the general principles of valuation? Now, what are the principles of valuation? Very, very theoretical. Just the headings we remember. It is enough. Okay. In almost all business valuations, there are some principles which are. So, if I want to fix the value of my phone, okay, how will I fix the value of my phone? Okay, how will you fix? So obviously you will first look at substitutes, that what if someone wants to buy the same phone with the same features, where will they go? Okay, because an investor will not pay more than that of a substitute available in the market. Similarly, alternatives. Okay, if there are many alternatives, obviously it will affect the valuation of the company. This is also to be understood. Second, I will look at, if I am buying a company, how much of a gain inflows they will give me over a period of time. So if I buy this company, like for example, Google bought over YouTube, then they will look at, listen, how much of YouTube will give me generation of, how much money will it generate. So you will study, and future cash flows can be brought down to present value also. So time value will also be given, will be done. So this is what they are saying. Principles of risk and return. Tell me one thing, would you want to invest in stock market, cryptocurrency? High rate of return is there. So obviously higher the risk, higher is the probability of return, but you don't want to take that much risk. So accordingly you keep a factor of risk and return. Expectation cash flow. So some of the points are repetitive only, but we can do the headings. And reasonableness. Okay, principle of reasonableness is to look at the nature, historical background, brand image, etc. Just all the reasonable practices and close it. So while doing valuation, I will do time value of money, I will look at the risk return, I will look at the substitute alternatives, reasonable expectation of cash flows, reasonableness and alternatives. Just headings and online is enough. Now we come to important part. Now moment you see Companies Act, any section, that chapter becomes important. First, principles or purpose of valuation. Sir, why valuation is done? Okay, why valuation is done? Purpose of valuation. See, valuation could be done for two reasons. Okay, valuations could be done for two reasons. One is the maybe non-statutory reasons, and the other one could be for statutory reasons. Sir, what does this mean? For example, if law mandates, so many times it is written that when a company is going for delisting, they have to do valuation of the share. So it becomes statutory reasons. If there is sweat equity, valuation might be doing. However, for some cases, if valuation is not prescribed by law that you have to only do a valuation, because someone is giving a loan, they might not do a valuation. So that comes on basis of your personal preferences on the transaction type. You might want to decide whether you want to do a valuation or no. It is optional if not law has not specified. So purpose could be strategic purposes, business purposes, or legal purposes why valuation is done. Let's see. Okay. Now, in India, I told you chapter number 17 of the Companies Act talks about valuation. Okay, that we need to have certain valuers, registered valuers, and in this you go to your section 247, subsection 1, 2, 3, 4, all we will do. Subsection 1 says that it is mandatory to do a valuation from a person who is registered with the institute. Okay, that is subsection 1, not given here. That you have to do from a registered valuer. So subsection 1 says that you have to do from a registered valuer. Subsection 2 says that the valuer shall, now the responsibilities on the valuer, that he should be impartial, he should exercise due diligence, he should follow the rules, and he should not take, now this is the fourth is important point, that the like how auditors, you should not be connected with the company. For valuation they say 3 years before the transaction and 3 years after the transaction you should not be connected with the company. So shall not take valuation directly or indirectly 3 years prior to appointment or 3 years after valuation of the assets conducted by him. So this is the first time they are saying that after I have done the valuation I cannot be connected with the company also. So the valuer has to ensure all of this. Now we come to the rules. The rules, okay. Now let's understand the company's registered valuer and valuations rules 2017. Now they say who is a registered valuer. So registered, so this person must be registered with other RVO, okay, registered valuer organization. What is a RVO? RVO enrolls these registered valuers. I'll come to it, don't worry. Okay, let's see, let's complete it. So first thing is your IBBI, okay, your Insolvency Bankruptcy Board of India. Okay, all insolvency related matters is dealt with IBBI. They register your first RVOs. So what is registered value organization? So what are these? So RVOs are basically CA, CS, CMA institutes. They have all form a Section 8 company and they have got registered as a RVO. What is the job of an RVO? Is just like how ICSI conducts examination for company secretary. RVOs, registered valuer organizations, all CA, CS, CMA have set up a Section 8 company called as ICAI RVO, ICSI RVO, ICWA RVO. They form themselves and then they conduct these examinations. They take action for professional misconduct. They charge fees. Okay, they set up valuation standards, etc. And all these valuation exams are done. So, are you clear with what is a RVO? If you clear your examination of CS, you become a company secretary. Similarly, if you clear your exam for RVO, you become a registered valuer. Concept clear, everyone? Simple little thing of what is RVO and this. Now, an individual shall be eligible to be and registered valuer if he is a fit and proper person. He has a proper expertise. He is a valuer is a member of an RVO, has completed the recognized educational qualification, has passed the examination and is recommended by RVO for registration. Very simple logical sense. That first point, if you would say, which is the most important point out here, that an individual will be allowed to be a registered valuer if he has cleared the exam, if he has failed the exam or he is giving, he just filled the exam form. He will not be allowed. So he has to first clear the exam, then have the necessary qualification, because sometimes now you have MSOP, TDOP, all those he has to complete and become a member. Now, valuation standards. I told you in the very start that valuation standards, right from before we come to our valuation rules 2017 of India, before that I have told you something, that in the very beginning for UK, what was the UK? I told you have to remember the RICS. What did they do? RICS published a red book which gave valuation standards and professional conduct to be followed by valuers. So they made standards for valuers. What does this red book do? After the property crash, they made standards for valuers. Similarly, USA also in 1980 also there was a property crash, and in 2008 also there was a property crash. Even they made made some universal uniform standards to be followed by valuers. Clear? Let's come to something important. Okay. Now we saw for your particular UK, USA we saw. Most important is, sir, what about India? So this I want you to quote in the exam, that is your chapter 17 read with section section 247. Sir, what does it talk about? Valuation provisions under Companies Act. So this has been given. Valuation in respect of a property shall be done by a person who is registered as a valuer only. Now let's do the subsections. Okay, so now this is actually your subsections. So this is your section 247. This is subsection 1, this is subsection 2, so on. Subsection 2 we have already done before, yes or no? Sir, what I told you na above, that the person should be impartial, should exercise due diligence, should make a valuation and should not be connected 3 years prior or 3 years after doing the valuation, right? And so this is subsection 2 we had already done above. Flip and see, same provision has been given. This is subsection 1 which I told you to write. That where a valuation is required under law, statutory valuation, then it has to be done by a person having qualification and registered as a valuer of a RVO, registered valuer organization. Then third talks about penal provision, that if the valuer contravenes anything, he will have a penalty and what all he will be liable. So if a valuer got penalty, then he can be liable to refund all the remuneration he has got and also pay for damages. So subsection, at least in the exam we can quote section 247 which is coming under chapter 17, and we can write the section numbers also. Subsection 1, 2, 3, 4. 4 says that what all he is liable to pay. So he has to refund his money that he has taken and he has to pay damages. Penal provisions are given here. 2 is about what all duties that he have, and 1 is about only a registered valuer can do a valuation. Concept clear? This I want you to quote in your examination. Clear? Let's see next. The registered valuer rules 2017. Sir, you did section, now we are going to do rules also. Answer is yes. What is a big deal? It's going to be pretty simple. We will be doing rule 3, rule 4, rule 5, everything will come. Okay, so in the examination you should be loaded with sections, subsections and the rules. So first, before we start for the valuation rules, we should at least know the rules are of which year, because this we have to quote in the exam. So companies registered valuers and valuation rules 2017. The central government, via its notification, has notified these rules. So good portion has increased for us. Okay. The notifications brings in clarity with respect to valuation. Common sense, it will bring in clarity. Okay, and it will standardize the prevalent diverse practices. So it will standardize, make all the multiple various methods of doing the valuation, they will make it uniform. They will improve and change the entire transparency. They will improve the governance. They will ensure that everything is more true, more correct, fair, complete, etc. Sir, okay, theory is done. Now let's start with the rule numbers. Now the rule numbers are important. Okay, just write down and close it. First is rule number 3, eligibility for registered valuers. Let's take for example, I have my younger brother. Okay, yeah, I have my younger brother. He is 2 years old. 2 years old. Allowed or not allowed? Quickly. Can he become a registered valuer? 2 years old. Answer is no, he should not be a minor. Okay. Let's say my elder sister. Can she be a valuer? Answer is no. Again, why? Because person of unsound mind is not allowed. Okay, just joking. Okay. Next is he should be a member of a RVO. First very simple rule is there. He should be recommended. Now obviously you should be a member and recommended by the RVO. So normally if you want to appoint a registered valuer, you write to the RVO that please recommend a valuer for my business, and they will do it. Okay. And then a person who has not cleared the examination cannot become a valuer. Common sense, they have to clear the examination and have to apply within 3 years of clearing the exam for registration. Means if a person has cleared the examination today, they have to apply for registration within 3 years to become a registered valuer. Should have the necessary qualification, should be a person resident of India, and your entire friend who always keeps borrowing money from you, he can also not become. Why? Because a person who is bankrupt cannot be allowed to be a valuer. Okay. And coming next, if a person who has been, now this is very similar to director disqualification, that if you have been convicted for a term exceeding 6 months, let's say if a valuer has been convicted for at least 6 months imprisonment, then for 5 years he cannot take up the job as a valuer. And if he is after 5 years he can, but if he has been imprisoned for an offense of 7 years or more, then he will never be able to become registered as a registered valuer. Okay. And no penalty has been levied against him. So these are is a fit and proper person. Very simple. So fit and proper person has not no income tax penalty has been put on him, not been convicted. Okay. Person resident of India, undischarged, insolvent. I told you, my friend, my sister, my younger brother, all examples I have given you. And the most important is rule number 3 is you should be a member and registered with the recommended by the RVU and clear your examination. I think the top 3 cracks it. Okay, this is exactly what is there. Now coming to a firm. Normally what happens? You think that all these valuers are one person, or normally they all come together and become a firm of valuers? So obviously they set up a firm. So even a firm is eligible to be registered as a registered valuer. So no partnership or company shall be eligible to a registered valuer if, so normally they can, but they will not be allowed if they have set up for any other objects. So if a firm is there, it's set up for marketing purpose, they cannot become registered valuers. If it is undergoing insolvency, okay, if all the partners or the directors are not eligible, so what does it say? That all the partners should be eligible. If all the partners are not eligible, then they cannot be a valuer only. Sir, why like that all the partners should be eligible? So the logic is pretty simple. What happens is, if valuation is not done properly or there is some fraud, then all the partners can be held liable. So obviously we want all competent partners only. Okay, so all the partners and directors should be eligible. If they are not eligible, none of them, the firm cannot be registered. Okay, 3 or all the partners, whichever is lower. So again, 3 or all the partners. Now understand what does it mean? At least 3 of the partners should be registered valuers, or all, whichever is lower. So imagine a firm having only 2 partners. A firm has only 2 partners. So 3 or all. So all, a firm has only 2 partners. So all of them is 2. So whichever is lower. So normally they're saying minimum 3. But if a firm has only 2 partners, then all of them should be registered valuer for the firm to be registered as a valuer. Okay. And none of its partners is a registered and none of its partners, so basically one of its partners should be registered for the asset class for which valuation is sought. Means, let's say if I am becoming a valuer for, there are these specific asset classes. Tell me different asset classes. There is gold, there is jewelry, there is land, there is property, there is shares. So even specific, there, once you clear your examination, then there are a specific kind of asset classes. One of the partner at least has to be a expert in that subdomain also. Now we come to qualification and experience under Rule 4. What does it talk about? Similarly, that you need to clear the examinations, etc. Okay. So you should be a member of a professional institute. This is where CS will come in. And at least 3 years of experience after such membership. So what is he saying? That an individual shall be eligible for registration under Rule 3 if he has a postgraduate degree. So again, if you are a CS, you have to clear the exam. So first you have to be a CS now and have some practice years of practice also. So if you are a membership of a professional institute like ICSI, ICAI, ICWA, then you should have at least 3 years of post membership qualification. If you don't have that, but you have a bachelor's degree only, then you have to have 5 years of experience. And if you are postgraduate, then they are saying 3 years of experience. So remember, for postgraduate and CS, only 3 years of post qualification experience is needed. Sir, remember we had done that CA, CS, CMA or CS is considered as a postgraduate only. That is why for them both 3 years of experience is needed. Then you can apply after clearing the examination. Clear? Then we come that valuation, examination and certificate. So on clearing, you will get a certificate of registration. Okay, once who passes the examination. Now we come to conduct of valuation. Means conduct of valuation means what? How will you do the valuation? You will comply with the valuation standards. You will fully disclose all the inputs that you have got. So again, you will do it as per international standards. You will do it as per valuation standards. If you have taken opinion of another valuer, you've taken help of another valuer, that fact also has to be disclosed. And in the end, you will make something called as a valuation report, like how you have your audit report. Valuation report will conduct the valuation, the background information about the company, why did the valuation was done, which method of valuation was used, when he was appointed, as on which date the value is there, and all those things. Now, shall function as given under the Act. Now, eligibility of RVO to be registered. Now, who are RVOs? I told you. So, RVOs are any organization that is a Section 8 company. So, they have to be a Section 8 company and registered with the IBBI. So, professional institute they have to form, and they can be formed as a society, Section 8 or a trust. So, either you form as a Section 8, you form as a society or a trust. So, all CA, CS, CMA have formed a Section 8 company and then they have got registered. Okay. And what is the job of this? Same what ICSI does. They will do for valuers. Conduct examination, grant membership, conduct training, monitor the review, the grievances will be heard, etc. Now, with this we finish the first part of the chapter, where we understood about valuation, the meaning of valuation, factors affecting valuation. Then we saw under, before coming to Companies Act, in UK Red Book and the US property crash in 2008 and 1980 they have mentioned. Then they came to Companies Act, chapter 17, section 247, 1, 2, 3, 4. Then they spoke about valuation rules 2017, and then they saw rule number 3, 4, 5, 6, all those in order. So that is all that you have to remember. Overview and just able to build your answer is enough. Now we start with the second part. Sir, what is your second part? Let's see. So second part is basically about SEBI. Sir, why SEBI and why ICDR has come here? See, remember, now talking about valuation of shares. Pay attention. When I say that there are different asset classes, one of the asset class, value of shares. Valuation of shares. Now imagine if you're doing it for a listed company, then obviously who will be the regulator? SEBI. And which law is applicable? SEBI ICDR regulations. Right? 2018 will be applicable. So sir, what will be given in this? So obviously, how much is the face value that you can keep? What is the price that you can keep? What is the price band you can keep? Okay, by when I have to issue these prices? What will be the valuation in case of preferential allotment? What will be the valuation in case of your sweat equity? What will be the valuation in case of delisting? What will be the valuation in case when a company is planning to do a takeover? So different scenarios have been captured and they are put up here. Okay, and then we will see that what they have given. Clear? So valuation has been said that the value should not be less than any of the following, and then you have to study. So this you have to make your notes, note it down with me, and you will be sorted. Okay. Now first one is about valuation of face value. Sir, face value. So company is allowed to freely keep whatever face value they want, and this face value has to be disclosed in the documents. So regulation number 27 of SEBI ICDR 2018 says that a disclosure of the face value has to be given. Okay, and face value of the equity shares shall be made in draft offer document, in the offer document, in the advertisement and the applications. Whenever they are giving a price band, every place disclose face value. So what is rule number 27 says about disclose face value everywhere. Now we come to your pricing, which is given under regulation number 28. Sir, what is regulation number 28? So they are saying that the price of a share, now face value is done. Now what about the price of share? So your price of share, and if it is a debenture, then the what will be the coupon of the debenture. So what is the rule with respect to that? So they say that you are free to determine the pricing of the share. It's your wish. You can determine how much you want in consultation with the lead manager. The lead manager is your merchant banker. This could be, if it is a fixed price issue, you can do it however you want, or if it is a book building issue. Okay, in book building issue, you have a red herring prospectus issue where a price is not given. Here the price, fixed price will be given, your price band will be given. So they say do whatever you want to do, big deal, do it in consultation with the merchant banker. So the issuer company may determine the price of the equity share or the price of the convertible issue, convertible debentures, etc., whatever they want, or even the coupon price for debentures. They can fix, or the conversion price, they can do whatever they want in consultation with the lead manager. And if the issuer doing through book building process, then they will also follow the process given under schedule 13. Okay. Now coming to the next one is price and price band. Sir, we did regulation number 27 face value. Then we did regulation number 28, which was the price of the shares. And now we are doing if details more about if there is a price band, by when it should be disclosed, what will be, how big the band can be, how small the band can be. So my first question is, does the company have to disclose in the offer document the price and the price band? Obviously, the issuer may. So now just remember this, that one is it could be a fixed price issue, or it could be a book building issue. In book building issue, red herring prospectus is issued, and in a fixed price issue, directly prospectus is issued. So what it is, normally if the company knows at what price they want to do, they will issue a fixed price, they will issue a prospectus and close it, that this is the price is 200. But if the company is not sure, or they want to fix the price on basis of market demand, then they will issue a red herring prospectus which will contain a price band. Bid from year to year on basis of bidding and request and demand, I will fix my final price. So the issuer may fix the price or the price band. So you can fix the price here and price band here. Okay. And determine a price at a later date before filing the prospectus with the registrar of companies. So if you want, you can determine the price at a later date, which is in case of red herring prospectus, and then once you have determined, then file the final prospectus here. So in book building issue, red herring prospectus, here you will file a prospectus later. That's what they have written. So very simple, very easy. So basically they are saying that you do a book fixed price issue or you do a book building issue. Fine. If you are doing book building issue, give the prospectus later. So very simple. Let's go next. But always remember, prospectus will always contain one price only. Red herring prospectus can contain price band, but the final prospectus will contain only one price. Done. Sir, what is the gap, the maximum gap of price band, the range? So it is 120%. So it can never be more than 20% of the face value. Means if I want to price my security as 100, this is my upper band and lower band, or you could say floor price, floor price, and this will be the floor and cap or upper band, upper price cap, floor and cap. So cap can be how much? Max. What is the max cap that can be there? Think and tell me. So they have told very simple that the gap between the floor price and the upper cap should not be more than max 120% of floor price. So take 100, do plus 120%, you will come to know the max it can be is 120. Okay. So simply what they are doing is 20% more you can do of the floor price. So the cap band shall be less than or equal to 120% of the floor price. Simple. The cap of the price shall be at least 105% of the floor. So this is the maximum. So max. So price band. Maximum can be how much? 120% of floor price. And minimum. So if I have the floor price of 100 and I keep the upper band as 101. So they will say for such a small amount, what bidding you are taking? Minimum it should be 5%. Clear? So 105% of floor price. So minimum this much difference and maximum difference is given. Okay. Your second point is about that. Price on the price band and the coupon road shall be max 120% and minimum 105% of floor price. So beautifully explained, understood. Let's go ahead. Okay, the floor price of the final price shall be less than obviously the floor price shall not be less than the face value. Common sense, na? Can I go below the face value? Answer is no, you cannot, and as it is, you are not allowed to issue shares at discount anymore. The issuer shall opt not to make the disclosure of the floor price, of the price band, etc. Means sometimes what happens, you don't want to disclose all the floor price. You want to know by when I can disclose the floor price or the band. So then they will say you can do it at least 2 working days before the issue opening date. So the issuer shall announce the floor price or the price band at least 2 working days before the issue opening date. So I can issue a red herring prospectus. It will not contain the price band also. But before 2 working days, I have to communicate what is a price band. Okay. Otherwise, how people will bid, where they will bid. So before opening of the issue, you have to tell. All the relevant financial ratios should be mentioned. Okay. And also disclose all the relevant financial ratios will also be disclosed on the company's website. Okay. With this, we have completed your this part. We've completed your regulation number 29. Now we'll go to regulation number 30. Sir, what is 30 talking about? Differential pricing. Sir, what is differential pricing? If my employees come, I'll give them at discount. If my existing shareholders come, I'll give them at discount. So my wish. So they are saying that you can keep different prices for different people allowed. But can I give a discount of 60%, 70% or maximum discount level is given? So the issuer may price securities at different prices. Different prices can be given. Now we can give it to retail individuals. For all these retail individuals who are there, different price for them. My existing shareholders, I can give them at a different price. Or to my employees, I can offer at a discount, less price. So first point is, you can issue a discount to RII, retail individual investors, your shareholders, existing shareholders, and your current employees. So discount or whatever can be given, differential pricing can be given, but max discount that you can allow is 10% at a price not lower than 10%. So you cannot give at a price, you cannot give a discount greater than 10% is what they are saying. In case of book building issue, now tell me one thing, for book building issue, now this is simple. The price offered to anchor investors shall not be lower than the price offered to other applicants. Anchor investors are those investors, they are bringing 10 crores or more in your business. They are QIBs. They have a lot of money. They are like Ambani, etc. coming in. So they don't need discount. Okay. So they are saying that anchor investors shall not be offered at securities at a price lower than what is given to all the other people. Simple. Anchor investors don't get discount. Ambani doesn't need a discount. For alternative book building method, they have given a separate alternative book building method. They have to comply with that schedule which they have given. And discount, if any, shall be expressed in rupee terms. So if any discount is being given, then that has to be given in rupee terms. So very simple. Regulation number 30 has been beautifully completed. So beautifully I am teaching her. Yes or no? Am I only my fan, or even you are liking my teaching? Again, what is differential pricing? Sir, prices can be given at different prices to different people. However, not more than 10%. Big shots don't need discount. Alternative book building method will follow schedule 13, and discount, if they are giving, they have to express in rupee terms. So if I am giving discount to employees, I will say them that how much discount am I giving? 20 rupees discount. That has to be shown in the offer document. Till now, is everything clear? Yes or no? Then we begin with another thing about some trading days, etc. that will come. Okay. Clear till here? Yes or no? Okay. Great. Now we start with the second massive thing which has come in the past exam question also. Let's see. Okay. What it is? Pricing of frequently traded shares if it is listed for at least 90 days. So they've given you regulation 164 and pricing if you are not listed for the second part. Yeah, and here the second part here is the pricing of equity shares if you are listed for less than 90 days as on the relevant date. Sir, what it is, I'm not understanding only. So again, pay attention. What are we doing? We are fixing, what are we doing? We are fixing price of equity shares. Till here it is clear with everyone. We are fixing the price of equity shares. Okay. For a company, if the equity share has been listed, so for a listed company, so we can say it is somewhere like a fixing of this regulation 164, right? Regulation 164. Yes. Now pay attention what they are given. They have said that when we have to fix the price, and this is more like a FPO because you're already listed, right? You're already listed, so now you're issuing new shares. So then they have said that if you are listed, so the pricing and the calculation, the valuation differs, but very slightly difference is there. Differs if you are listed for 90 days or more, or if you are listed, this is the second part, if you are listed for less than 90 days. So first part will be when I am listed for 90 days or more, and second part will be the pricing I have to follow when I am listed for less than 90 days. So for example, if a company is there, it is listed for 100 years. So which method will be followed? We will follow the first method. And let's say another company which has just got listed and wants to issue shares, then they will follow the second method. Simple. Let's see. Let's begin and close. Okay. If the equity shares has been listed for on a recognized stock exchange for a period of 90 days or more, then the price of equity shares to be allotted pursuant to a preferential issue. Okay, this is for preferential issue, shall not be less than higher of the following. So preferential issue shall not be less than higher of the following. So figure out which is the higher of the following, and you cannot issue at a price lower than that. For example, if I figured out that the price here came 120 and here came 180 rupees, so I cannot issue at a price less than higher. So which is higher? 120. So I cannot issue at a price less than 120. Simple. So what are the two thresholds? One is you are listed for 90 days, na? 90 days or more. So then I will take the 90 days average share price, called as volume weighted average price. Volume weighted average price of the share means the average price will be taken, and the last 10 days WAP will also be taken, weighted volume average price. These two also I will take. This is one thing. So you can see point A, point B, right here point C. Point C, write it down. What it says that third, if the articles are provided for a different method, that also has to be taken into consideration. Whichever is the highest. So for example, here when I took the articles, and articles has given a method of calculating preferential issue and it is coming to 150. Then I cannot issue at a price lower than 150. Higher of these three things. So let's come back to the rule and done. Okay. So the first rule is, if I am listed on the, now this is what we are doing. If you are listed for greater than 90 days, I am listed for greater than 90 days, then I will look at the 90 days price, I will look at the last 10 days price, and I will look at if the article is giving a method of calculation of the share price. All the three I will see whichever is the highest, which is the highest here. So I cannot issue at a price lower than highest of all these three. Concept clear? Yes or no? 90 days, 10 days articles, volume weighted average price I will take. Now second scenario is if I have listed for less than 90 days. Points are exactly the same. See, if I am listed for less than 90 days, average 90 days stock price I will take, articles price I will take. So here you will write D. So here they have added one more. You will write C, and here you will write D for articles. So articles is point is same. If the articles is providing for a method, you have to see that also. Last 10 day volume weighted average price also I'll take. Now I cannot take 90 days price. Now 90 I can't put because they're not listed. So they say for how much ever time you're listed, take a price of that. So average volume weighted average price you will take for the price during you have been listed. So how many ever days you are listed, take a WAP volume weighted average price of that much time period. So they say okay, for whatever time it is there I will take. And then if they are saying one more point, they are adding that if you have done a M&A recently, M&A, mergers and amalgamation scheme, you have launched under 230 to 240 and you have figured out price there. So four things I will see, highest of this I will take, and I cannot issue at a price lower than what is coming in the highest of all these four. So if I look graphically, it will look something like this. If I am listed for less than 90 days, then I will look the price computed under M&A, if any. I will look at the 10 days past period. I will look at the AOA method, if it has given any method for calculation. I will look for the period that is listed. I will look at that. And one important thing here is connected here. Now pay attention. One small little point will come here. That this. Now this you have taken the average price during the period you have been listed, for the time period you were listed, right? You took a average price, average volume, your volume weighted average price you took for the time period you were listed. Now you have to do recomputation. Now pay attention to this other thing, okay? That under sub-regulation 2, so in the sub-regulation 2, where you were listed for less than 90 days, moment 90 days gets over, you have to do a recomputation and then compare. And if it turns out that it was higher, let's see here. So here we had seen 90 days. What was the 4 points? M&A, 10 days, AOA, and how much ever period you were listed. We came to know this is the highest price. So you can not issue at a price lower than 240. Now they are saying that 90 days when it gets over, when 90 days gets over, you have to do a recomputation. After 90 days gets over, so the thing is not over. After 90 days, again you will do a recomputation, and he came to know that it is at 260. Then you will say that, listen, we had issued at 240. Now the difference you have to pay. So whenever company is issuing preferential issue and it is less than 90 days, they will tell the investor that, listen, we will do a recomputation. Any difference you will have to pay. Clear? So recomputation will be done after 90 days. Okay. Recomputation will be done after 90 days, and if the recomputed price is higher than above all them, then the difference will have to be paid by the allottees to the issuer. Simple. So we did, when we were doing all this all this was about preferential issue. So all this you can write it here is about preferential issue. So 90 days, 10 days articles. In the other ones is whatever period is there, 10 days articles and AOA, and recomputation you will write. Now they are saying that if above one you are giving it to non-QIB, above you are doing it to non-QIB. Now if you are giving a preferential issue to QIB, very simple point, they have said only one rule, remember, close it. So they, if in the exam they will say that if you have done a preferential issue to QIB, the above one was to non-QIB. If it is for QIB not exceeding 5 in number, then you will issue it at a price not less than 10 volume weighted average price, and articles point also you will do. If articles provide, so 1 point you will do and 2 points for QIB preferential allotment. Then they have said that no allotment, very simple, no allotment shall be made to any QIB who is related to the promoter. So obviously we cannot issue a promoter cannot issue it to a QIB if they are related. Now it is deemed to be related if the QIB has a veto rights, if the we have entered into some shareholders agreement priorly, or they have a right to appoint nominee directors. So what are they saying? That a company cannot issue preferential allotment to QIB if they are related to the promoters. Example that if the following things are done, you are deemed to be related, and that is why you will not be issued to promoter. Now we are done with this, the first part. Okay, clear till here? Is everything clear? Yes or no? Okay, so 5 marks they ask here and there, they always ask from all these things. Okay, great. Now let's begin with the other part. Now Security Exchange Board of India Share Based Employee Benefits Regulations 2011. Now pay attention to this. Tell me one thing, this is for listed company or unlisted company? SEBI Share Based Employee Benefits Sweat Equity Regulation 2021. It's obviously we are issuing equity shares, sweat equity. For listed company, then these rules will be followed, 17, 11, I'll come to it. And if it is to unlisted company, sweat equity to unlisted company, then you will follow Companies Act section 58 or section 54 rule 8. So sir, what are you saying? So pay attention to what am I saying, that if you are issuing sweat equity or any kind of employee benefits, okay, you are issuing to a listed company is issuing, then they have to follow with SEBI SEBS regulations, sweat equity and this regulations. And if it is an unlisted company, you will follow section 54 read with rule 8. Is this clear? In the exam they ask all these questions, they ask, right, what is the pricing methodology for listed companies, and you will write SEBI regulations. If they say what is for unlisted company, then you will write there. Now I'm just thinking that what is happening is employee benefits are being issued, so obviously they will not be given at market price, they will be given at lower than market price. So what will happen here according to you? What do you think will happen? Obviously a registered valuer will be appointed. Registered valuer will be appointed. He will apply the valuation principles, etc. Let's see. Okay. That employee stock option. So which is the regulation name? SEBI Share Based Employee Benefits and Sweat Equity Regulation 2011. That the company granting the options to its employees pursuant to ESOS, okay, shall be free to determine the exercise price. So the first line is you're free to determine the exercise price, how much ever discount you want to give, but just conform to the accounting policies. Second, they say that the accounting standard should be followed, okay, and there is a guidance note for employee share based payments that also has to be adhered. So fine. So first point is you're free to determine exercise price. Second, what they say that the accounting standard should be complied. Okay, fine, accounting standards will be followed. Third is regulation number 22, that you have to confirm with the accounting policy, then you have to give a minimum 1 year lock-in period. Okay, then if it is a part of public issue, now very logical, if it is a part of public issue and the employees are bought at the same price, then there will be no lock-in period. Common sense that if the employee is buying at the market price, then how you can have a lock-in period? So if this ESPS is given at a public price and the employee is buying at the same price as that of public, then there will not be any lock-in period. Otherwise, there will be a 1 year lock-in period. Means what? Minimum 1 year. So company will say that you work for minimum 1 year, then you will get these rights. Okay, then you can convert these ESOPs into your shares. Now, what if he dies in between? What if he becomes permanent disabled? Then will the lock-in period apply? So here they are saying that, okay, so first point they are saying that if the company gets amalgamated, then this should be transferred. The benefit should be transferred, okay, to the other company. So how much ever time period you hold in the transferor company, that will be counted in the transferee company also. In event of death or permanent incapacity, the requirement of lock-in period shall not be applicable from the date of the death. So if a person has died during the lock-in period, he can get all the shares as well. Now coming to your price of equity shares shall be according to the pricing method stipulated under the preferential issue to a person other than qualified QIBs under this. So how will the minimum pricing be there? The price of sweat equity shall be determined according to the pricing. Sir, where is this given? Here for non-QIB, it is your regulation number. Can anyone tell me? We just did this. We just did this, na? That this one, your regulation 164. This is for non-QIB. So these are all non-QIB. So your even in sweat equity, this only will be followed. Okay, simple. Now moving forward to what if it is, sir, sweat equity, but for it is sweat equity but for this other thing, unlisted company. Very good. So if it is a unlisted company and they are issuing sweat equity, now you think they will have all these main regulations applicable, SEBI regulation? Answer is no. So very simple. What they have said that a valuer will be appointed. The registered valuer will try to study that particular what kind of intellectual property he is giving, will try to value it. He will give a justification for this valuation, that this property that the employee is giving is worth so and so, and that is why against that so many shares are being issued. A valuation report will be prepared and it can be shared to the shareholders also. Now accounting treatment. Now pay attention to the accounting treatment for sweat equity. Now sweat equity is what? Pay attention. Okay, what are they saying? That if it is a how it will be shown in the books of account? How it will be shown in the books of account? Very simple. So if a intellectual property, if what is sweat equity? Pay attention. What is sweat equity? Is company is normally when they issue to anyone, employees. Okay, let's say they are issuing shares. So if the company issues shares to the employees, normally the employees would have paid money. Now they are not giving money, they are giving intellectual property rights. So what this is called as sweat equity. What do you mean by sweat equity? Sweat equity is issue of equity shares for non-cash consideration. This non-cash could be technological know-how, any kind of intellectual property, etc. So the shareholder is giving intellectual property, against that company is giving shares. Now the question comes that how will this be shown in the balance sheet, in the accounts? So here they have said that the company has purchased this intellectual property. So they have two options, either to put it in the profit and loss or to put it in the balance sheet. If they put it in the balance sheet, it will be treated as an asset. So software is also an asset now. So if they want, they can put it in the balance sheet asset side as a software, or they can put it in as a expense, that profit and loss. How you buy an antivirus software, not everything goes in the balance sheet. Company must have bought something, so if they have bought it and it's not very valuable, not very thing, then they can show it in the books of account as an expense. So ideally company will always prefer to show it in the asset side, because the assets value will increase. However, if the auditor is saying that this is not that big, valuer is saying it's not that big to go in balance sheet, you can show it as a purchase expense only. So whatever, two methods they have shown. Accounting treatment, where the shares, where the equity shares are issued for non-cash consideration, such non-cash consideration shall be treated as in the books of account as an asset, then it will be put into the balance sheet. If it is not being in the balance sheet, then it will be expensed out and put into the profit and loss account. Simple. Then we go to the next thing. So 164 we have done. Then we did this for listed companies, sweat equity, unlisted also we did. Now they say for delisting. Sir, what is delisting? So when a company gets listed on a stock exchange, they follow with SEBI laws. But when they get delisting, they have to get delisted in accordance with SEBI delisting regulations 2021. Sir, now I have to learn the pricing that for a delisted company, what will be the price? So for them, they have simply said that the floor price, the base minimum price, will be determined as per Regulation 8 of Takeover Code. So Regulation 8 of Takeover Code talks about open offer, how the calculation for open offer. So simple, that when a company is getting delisted and they want to set the floor price will be as per Regulation number 8. So what is floor price, sir? Okay, so let's see. Now pay attention to this. Okay, so what is it that when as per delisting regulation, now delisting regulations, so it is mandatory on the promoter to give exit opportunity to investors. He should give exit opportunity to the investors, because investors would want to sell their shares and run away, because now they will be earlier they were shareholders of a listed company. Now after delisting, they will be shares of unlisted company and very difficult to liquidate. So as per the delisting regulations, promoters mandatorily have to give a exit opportunity. Now the promoters will issue something called as a price band, but this is called as reverse book building. See, normally what happens in book building, it comes at the time of issue of shares. People will bid at what price they will buy. In reverse book building, the shareholders will bid at what price they will sell. Okay, and as per the delisting regulation, they have to buy at least 90% of the shares. So they have to buy at least 90% of the exit opportunity should be given, and they should be ready to buy out 90% of the investors whoever want to exit. Now, what are they saying? That the promoter will have to give a price band. So a floor price will be given, floor price, and they will give a upper band. Okay, floor price and the cap price. Cap price will be given. Now, floor price, how will we determine that this much is the minimum he should be ready to buy out? Promoter will say, I'll give you 10 paisa. So they say no. Floor price will be determined as per regulation number 8 of SEBI takeover code. So as per takeover code, regulation number 8 tells how pricing can be found. That you get it, you will keep it here, it is a floor price, and upper band will be there. Within this, people will bid at what price they are ready to sell. To determine in the final that how he has to purchase only 90%. So in the end, it will come out that what is the final price will be determined on the bidding amount. That final price is called as discovered price. The discovered price is after the bidding, etc. You discovered what is the price. So let's move ahead and quickly finish it off. Okay. So what it is, that regulation number 8. So after fixation of the floor price, the discovered price will be determined through reverse book building. Sir, beautifully explained. Discovered price will be determined through the reverse book building. For floor price, how it you will fix the floor price? Go as per takeover code and fix the floor price. Okay. Then the indicative price can be given. If the promoter wants, he can indicate a price that this price I am ready to buy, etc. It can be higher than the floor price. So he can indicate at what, even though the floor price is there, indicative price can be given that I am ready to buy at this price. Promoters can mention. So that also will be declared. Okay, higher price than discovered price. So acquirer may pay a higher price than the discovered price if he deems fit. So if the promoter is ready to pay shareholders more, absolutely fine. Okay, now we come to your SAST regulation. We saw the how the price is computed is given in regulation number 8 SEBI takeover code, so that you can read it from the takeover code regulation. Now we talk about consolidated FDI policy. Sir, why it is important? Okay, so okay, very simple. Sir, valuation in case of foreign direct investment. So now pay attention that normally when a foreign company is investing in India, so it is a FDI. So this is the company they are investing, it is a FDI. So maybe they could invest in a listed company, or they could invest in a private or unlisted company also. Now the question comes that at what price it will be issued. So there is a investor, foreign investor. He is ready to pump in money into the company. Now we have to issue shares at him. So what will be the value of the shares that we issue to them? So they have said that very simple, if okay, only one main rule is there, that they cannot issue at a price to foreigners a price lower than what you give it to a resident investor. So if I give it to Indians at 110, to foreigners you cannot give a bigger discount. You have to sell at higher prices only to, or same prices to the foreigners. That's it. So in case of foreign direct investment, the price of shares to be issued to resident outside India shall not be less than price worked out by SEBI. If SEBI will come in if it's a listed company. If it is unlisted company, then a price worked out by a registered valuer as per internationally recognized practices, or the price available in the past, price which has gone from resident to non-resident as per RBI guidelines, where shares are issued on preferential allotment. So basically they're just saying that if in the past RBI has issued any price, SEBI has issued any price, or registered, highest of these two you will give. Now comes requirement, evaluation requirements under different statutes in India. Now what happened is, I told you valuation can be recommended as a law, or it could be as a non statutory thing also. You want to voluntarily do it. In various act where it is told that valuation is mandatory. So we will see under Companies Act which are the sections which are telling that valuation is mandatory. We will look under the IBC code, insolvency, when valuation is mandatory. We will look under SEBI Act, Income Tax Act, FEMA Act, etc. Various acts where it is told valuation is needed. So basically you can just read through, not important, like when a Companies Act, when your issue of shares, issue of sweat equity, issue of ESOPs, issue of preferential issue, deposits, okay, compromise arrangement to identify whether you're minority shareholder, M&A, okay, all this is needed. Now Rule 8 says that the conduct of the valuation in terms, mandatory contents to be stated by the valuer in the valuation report. So the valuation report should contain what all? Just logically think. First, if I'm a valuer, I will mention the basic details about the company, the purpose why we are doing the valuation. We will also say who is the company for whom we are doing the valuation, what is the methodology that we have used, any kind of assumptions that we have taken. Okay, all those will be given. So it's a very simple contents of a valuation report. Background, purpose of valuation, they will identify who he is, any conflict of interest if any will be told, appointment date, inspection done, major factors, etc. Okay, now comes valuation expression of value. Okay, 2 minutes. Just read through this, and till now tell me in the chat box, have you understood everything or not? Just have a water and we'll continue. Okay, so now we continue. What valuation expression of value? Okay, now what it is, they are telling you different kinds of value. Okay, so if I tell you value means, you will say the worth of the company, the purpose. However, value changes. Okay, so maybe for municipal value might be different, fair market value will be different, etc. So let's look at different expressions. They can definitely ask you for 5 marks. Okay, 5 marks, or 2 things they will tell you to for 5 marks. So first one is fair market value. So fair market value, fair means the correct price. Fair means a reasonable price, a proper negotiated price. We are not talking of any sold in compulsion. Any kind of distress sale is not covered here. Okay, fair means what? A reasonable price that you have got. Now market price, moment I say market means what? You've gone in the market and sold out. So when I say market means, it is between a buyer and a seller, real buyer and seller. So when I go in the market and I sell my mobile, that is the fair market value which in the market I have got for buying and selling. So the amount for which an asset or liability would be exchanged between a willing buyer and willing seller at arm's length price. Arm's length price means what are the fair price at a reasonable price with unrelated person, and you got a proper amount where both the parties have proper knowledge of what they are doing. They have done it prudently and without any compulsion. They have done their negotiation, etc., and properly they are selling without any compulsion. Very simple. So distress sale will not come here. A person who is doesn't know the value of the goods and just randomly selling will not come here. So fair market value, you have to write buyer and seller. Very similar to fair value. Sir, what is fair value? Fair value means it is a approximate figure that you should fetch in the market. The above one is actually between a buyer and seller, what is there. So for example, my fair value of my mobile phone could be, the fair value of my mobile phone could be 30,000. Okay, so fair value could be 30,000. But when I go in the market, I might not get 30,000. I might get an amount little bit up and down, but it will be close by this only. So again, fair value is a reasonable expectation. Okay, and above one, market value is between the buyer and seller. This is the knockout price. This is the sale price. So this is a orderly sale. Inorderly sale is basically a distress sale that you have done. So it's not a distress sale, it's a fair price that you have received on a asset, okay, which would be received in between market participants. So this is something that you would have received when you actually go in the market. Maybe there must be some up and down. That is the fair market value. Okay, is the exit price when you go to sell. It is between market transactions, market participants, and it is an orderly transaction. Orderly means what? It is not a forced sale or it is not a distress sale. It is an orderly transaction. Simple. Then comes, sir, what is book value? So book value is the balance sheet value. Balance sheet value as on appearing on the balance sheet. So I take all the assets less liabilities. Normally I go to open the balance sheet, look the asset less the outside liabilities, whatever it is the net worth of the company or the book value. It has nothing to look at the market prices. So all the historical figures appearing in the balance sheet is to be taken. So book value is a historical value. Okay. So for example, if land is given, so land might be there, but in real market it might be something else. So we don't care of that. Historical prices will be there. It is the difference between assets less liabilities, as we do net worth. Okay, simple. Then we come intrinsic value. So in intrinsic value, it's your NPV method. Capital budgeting you have done. So intrinsic value takes into account present value of money. That means any future money that comes in will be discounted to present value. Okay, so in intrinsic value, the real value of the company, qualitative, quantitative. So qualitative could be with respect to the board, their performance, the ethical company. Okay, all those qualitative factors can be looked, the goodwill, image, and quantitative could be the cash flows, all of that. Okay, and does not consider the market value. We just take the expected future cash flows and we discount it to present value, applying a proper discount rate or PV factor. Simple. You can write it and close it. So what is qualitative factors like the company's performance, productive, business management, etc. And quantitative are all financial numbers. So intrinsic value, please write about capital budgeting, PV factor method. Now we come to replacement value. Sir, what is replacement value? And just look down below. Here they talk about reproduction value. So I want you to learn two things: replacement value and reproductive value. So replacement means what? For example, if my AC is not working, you will want to replace it with a new one. So the price of the new AC is the replacement value. So today I will be thinking that if today I have this machinery, but if I want to knock it off, then what is the real price that I will have to pay in the market? So the price of substitution of by a new machinery, which will do the same nearest equivalent utility. So replacement value is the current cost of acquiring a similar property which is likely to produce the nearest equivalent utility. Okay, so you are just replacing the current machine with the new materials and technology. Done. Sir, then what is reproduction value? Mark as reproduction value is important. Now reproduction value is basically you get the duplicate asset with the same condition. So for example, if I want to see that if I have a 2-year-old phone, if I replace it with exactly a 2-year-old phone, how much will it cost? So that is called as reproduction value or a replica value or a duplicate asset value. So in replacement method, what do? You replace it with a new asset. In reproduction method, you replace it with a duplicate asset in the same condition. So then you will compare that, this is the value. Going concern basis is basically the value of a business is calculated on going concern basis, means the current cash flows are expected to continue in future. A going concern basis will be more valuable than a company which is not going in concern, which is at the time of liquidation you might not get that much value. Okay, so factors like your trained employees, brand generate greater value, because all these assets and intangible assets will generate benefit to me. So you would want to buy a going concern company or a company which is going in liquidation. So a going company concern basis is good because the asset keeps generating money in future also, whereas in liquidation, now the asset is just sold and that is much you have got. Okay, so standard 102 says going concern value is the business enterprise that is expected to continue and operate in future also. Okay, okay. Now we go. So this is given example that basically a company which is going in liquidation is only 10 million worth, but if a company would be a going concern, it would be much more worth, because obviously assets would be generating more future. Now equity interest value. Now understand what is equity interest value. Very, very simple. It is about this calculation, a very simple calculation, that equity interest value. Okay, what is the value of my equity shares? So just remember ROI. How do you calculate return of interest on shares? So for example, if I had bought shares and it has given me dividend of 10 rupees. Dividend I have got 10 and I have got capital gains. Okay, capital gains of 20 rupees. And I had invested 100 rupees. So this was the investment price. Can anyone tell me what is the return on investment? So obviously you've earned 30 rupees on 100, so that is 30%. So this is nothing but equity interest calculation, your ROI. Sir, what did you do? I took dividend plus the capital gains. Capital gains means the P1 minus P0. So my original price must be 100 and I have sold it for 120. So I have got a capital gain of 20. So let's see what they have given. That's it. You can draw the formula also. That equity interest of an investor shall be considered while doing a investment. So while making an investment, we will see how much ROI is there. Okay, because it will be assumed that this will continue in future also. The purchase of equity shares as a long-term investment can be different as compared to a short-term investment. Coming back, return on equity investment is equal to the dividend plus the capital gains divided by the market price. Write it in your own words and close it. Insurable value. Now, what does the word insurable value mean? So, insurable value is always of insurable. So, what the insurance company is fixing the value. So, whenever you take an insurance, they will study the particular asset and fix the value, that is called as insurable value. Now, insurable value is always calculated of destructible assets only. So in your company, you can do an insurance of machinery, you can do a insurance of building, you can do an insurance of your goods, but you can never do insurance of land. Okay, insurable value does not include land because land is non-destructible. So only your destructible things you will do and it gets insured. So that is your insurable value. Now in your M&A etc., you would look at whether the business has insured all its assets or no. If not, then you will have to look that, listen, this company is not done, I might have to pay for the insurance is done needed. Okay, now we come to two things, which is value in use and value in exchange. Now this is very similar to what we had done above. Pay attention when I say, and just remember the word asset instead of value. Remember the word asset if it is in use or it is not in use, it is going to be exchanged for money. Okay. Now when I say when we are done it above, can anyone tell me what was the concept there? So this we are told it was going concern basis. Going concern basis, right? So always in use means it is currently in use. It will continue its operation and therefore it is more valuable. Whereas when it is not in going concern means it is going under liquidation and the entire asset will only be sold. So that is called as in exchange, means the asset will be sold and without any role in business, without being able to generate any future income, we are selling this individual item. Okay, so obviously value in exchange might be lower because it is sold piecemeal without any business benefit. Then we come to goodwill value. Now goodwill is very simple. Goodwill is if the anything which you have get over and above the market price is called as goodwill. Okay, goodwill you get on your assets, intangible assets, and for future benefits, etc. It is a quality. Let's see what does goodwill mean. When we do M&A, and that time you see that if the consideration paid is 12 crores, but the net asset value is only 10 crores. So why did we give 2 crores more? If the assets are worth 10 crores, but still we are paying 12 crores. So 2 crores will be goodwill, and it is shown also in the accounting treatment as goodwill. Now we come to salvage value. Now salvage value means the scrap value of goods. Now understand that as per Income Tax Act, certain assets have certain set lives. For example, they might say that the computer might only be has a life of 5 years, even though you might use it for more than 5 years. Okay, so that means that the life of the asset might be more, but law sets a certain life, and when you go to sell, you might get something, at least scrap also has value. It will never be zero. The salvage is a sale that you realize at the time of selling the asset, because it can no longer be used for service. Now salvage is not same as zero because you get always some amount. Okay, asset might not be useless to everyone. So knowledge of the salvage value in the target company is significant for acquisition decision. To know that if I am going to sell off these assets, how much I will get. Liquidation value is when goods are sold on piecemeal, not on going concern basis. Okay, now liquidation is carried out in two ways. Maybe it is an orderly transaction or it is a forced transaction. So orderly transaction would be when you have a good enough time and you get a good fair price. It is an orderly transaction. But if your lender is not, creditor is not ready, in a short time you want to sell, then you might have to liquidate at as a forced transaction, distress sale. Now when we look at this table, it's super simple. Pay attention. It's a super simple transaction. Can you tell me that all these types of values that we have done, which is the lowest form? Lowest form. So the let's say this is 0. Can I say scrap value will come here? Scrap value is lowest point. Explain what is scrap value at the time of sale. Just above that would be a forced liquidation, wherein forced transaction, a forced or a distress sale, you're getting some amount. That is a forced or liquidation. Third one could be a orderly liquidation. So you are liquidating, you're doing a peaceful sale, piecemeal sale, but properly you're doing it with time, selling and getting a good price. Now fourth will be value in use. So if you have, just remember, instead of value, asset in use. So asset is in use, it's going on a going concern basis. Obviously you will get more consideration here. Then comes all your tangible assets. All your combined tangible assets are worth 10 crores, but if you are getting 12 crores, then this is due to goodwill. Just to explain goodwill, they've given you net tangible assets are here, but you are getting 12 crores. 2 crores is goodwill. And when you add up, okay, the total value of your business on paper could be much more. So these are all your limits, it ends here. Clear? Then price and value differentiation. Tell me one thing, is the price and value same? Is the price of goods and value same? Think and tell me. Answer is no. Price is what you pay, value is what you bought. Okay, value is the real worth of a product. For example, if you go for a water bottle, you just go to take a glass of water. So water might be for 20 rupees. So water half liter will be for 20 rupees. But let's say is you are in a desert and there is no other shop around you, and one person has come and same half liter of bottle, he's saying I will charge 500 rupees. You might pay for it because the value might be 20 rupees only, but the market prices are dependent on demand and supply. They are always dependent on demand and supply. So sometimes even goods which is valued at 20 might go at 10 rupees, or it might go at 500 rupees because of demand supply aspects. Okay. Now imagine another thing, that if you have a pen might cost you 20 rupees. But let's say you have forgotten to take your pen in your exam hall and someone outside is selling the pen. He will sell for 50 also, you will take. 500 also you will take. Okay. So price and value is normally taken interchangeably, but they are not. Price is dependent on demand and supply, and whereas value is about the real worth of the company. Okay. Then process of valuation, purpose, etc. methodologies are given. Now we'll see the methods of valuation. Again, this thing will be repeated later in the next chapter, but just remember your market approach. Market approach could be called as your net asset approach. Net asset approach. What do you do? Let's see what they've given you. Yeah. Okay. So 3 methods of valuation. Let's do it here. In market approach, what are they saying? That you look at certain market prices. Market approach is a valuation approach which uses prices generated by market. So it uses prices generated by market forces, etc. One, I'll explain to you with example, but let's see what all points they've given. Okay, in market approach, valuer has reliable information about the comparable assets. So we have information about comparable or identical assets, and it is a orderly transaction. Very simple. Let's take a particular, let's take in real estate. Okay, let's say you own, what can you tell me in the WhatsApp, your house, your flat is how many square feet? Let's say if your house is 700 square feet, okay, and in your building this same flat, okay, on the same floor has gone for around 2 crore rupees. So what is happening is, this is a past transaction. This is a past transaction of a comparable asset. So accordingly, I will come to know that your house will also be around 2 crore rupees if it is the same square feet, same building, same view. So this is what they are saying. Okay. And they tell you also that this is mostly used in real estate, etc. Or if a company has been bought over, similar size in the similar industry. So let's say if we have Coke, which has a valuation of 20 crores. So similarly, we know Pepsi is also around 20 crores if they have all the same matrix. So valuers shall not be, this method should not be used when there are no comparable assets, nothing is traded properly, we don't have sufficient information, there are no recent transactions, and there are material differences between the two assets. Then we will not use it. Then we come to the NPV method. Sir, NPV method is same as income approach. All your future cash flows and inflows will be brought to present value, and then the value of the company is found, and then you would invest. So for example, if I want to see that this company is there, it is generating so much income, so this will be income in future, I will all bring it down to present value, and then see how much money I should remove today. Cost approach. Okay, now in cost approach, remember, we are seeing the cost of substitute. Two methods I have taught you, you can write it here and close. Replacement cost and production cost. Okay, so I told you here also same thing they do. Replacement cost, same utility. Okay, like no person will pay more than the cost of a substitute. The buyer will not pay more for an asset than the cost to obtain an asset of equal utility. For example, if I'm going to buy something which is very same and it is rupees 10. So you will not pay anything more if I'm getting an exact direct substitute for another price. Okay. And you can mention about what is replacement method when new asset is there, and reproduction method where the replica of the same condition is brought in. Now principles of valuation, this will come in the end. Okay, we will see. Do the headings. Yeah. Principles of valuation will come in the end. We'll do that. Hindrances or bottlenecks in valuation. So if I'm doing a valuation, what all are the problems, obstacles, etc. Now valuation is completely vague. Okay, it's a vague concept. It will have different valuers, will have different concepts. Second, different opinions. Uncertainty in valuation. Now obviously value keeps fluctuating. So even if I fix now, market forces keep fluctuating and competition keeps coming. So the valuation keeps changing a lot. Then inherent subjectivity. Now may be considered as a science, but it requires subjectivity, a perfect knowledge of the value. So no market force will know the exact value of a price. Each value is context specific. Means you can write a context specific means what? That maybe in this situation someone is ready to pay this much, someone else will value the same company in a different situation differently. Everything is, all the assumptions are hypothetical. Okay, cost and value, very difficult to do, and it can be very well exploited by man. Okay, assumptions, market comparables are not easy to find. Valuation standards might not be used, very critical to use the valuation standards, etc. Okay, now remember I told you that these principles will come in the end. So these principles you can write. Very important is general, that headings you can do, that core valuation principle. So if I'm a valuer, I have to ensure that everything is done with market integrity. I should be competent, I should comply. Okay, the basis of valuation, the reason for doing the value should be there. Effective date and valuation date should be given. All the assumptions, headings you can do, scope of work, all these things shall be informed. Okay, with this we have completed the entire chapter. Thank you. Clear till here? Have you all understood, yes or no, in the chat box? Okay, great. Now I will be starting with the next chapter, that is your lesson number 13. We are doing lesson number 13. Okay, now we'll be doing lesson number 13, which is your other one. So 20 marks we wanted in your 1700 square feet. Great. Okay, and Suyash, thank you so much for your kind message, means a lot. Now we'll be doing this other chapter, which is your valuation of business. Valuation of business. This is your lesson 13. Okay, so we'll just take a 10-minute break and we'll come back. 10 minutes, till that you want, you can revise it. Then I will come and complete it for you. So we return by 9:15. Okay. Very well understood, Divya. That's great. Okay. So dinner break. Okay. So cool. So we'll begin. Okay. I just need you all in the chat box, GTG in the chat box, and we can quickly start and finish. Okay. GTG in the chat box so we can quickly start and finish. Everyone, GTG in the chat box. We will start and complete this entire chapter. Okay. So I need a kind of a response from you all. Am I audible, visible, so I can quickly start? GTG, great. Gautami, great. Thank you so much for responding. The more faster you respond, it's easier for me to move ahead and understand. Okay. So let's begin. Hi. So we will be starting with a lesson called as valuation of business and assets for corporate restructuring. Here when we say valuation of business and assets, here they will be talking about the various methods of valuation. Before we start business valuation, what do you mean by the term valuation? Now earlier we had seen the simple meaning of valuation is to identify the worth of an asset. Here when I talk about business valuation, it is basically valuation of an asset. Here is a business. So you try to determine the economic worth of a business looking at its past and future aspects. Okay. Now during valuation, company not only looks at the past performance, but they also look at the future earnings of the company. Okay. And as you go out to shop, you would want to make a good intelligent decision. If you make a proper valuation of the asset, you will get to pay a good price and make a benefit. Now in business, when we saw corporate restructuring is nothing but M&A, mergers, amalgamation, takeovers, etc. During all this process, it is mandatory under law, okay, in multiple sections where it is said that you have to do a valuation. Okay. So, sir, in M&A, merger and amalgamation, where valuation is done. So, let me tell you that whenever you do a valuation, you have to fix a swap ratio. Obviously, a swap ratio, right? So, let's say if company A is merging with company B, company A is merging with company B, and they are becoming company AB. They are becoming company AB. So, obviously, we would want to know that the shareholders of A, how many shares they will get of AB, shareholders of B, how many shares they will get of company, the new company. So for how many shares of old company against the old company shares, how many shares they will get in the new company. So only when I determine the value of both the companies, the swap ratio can be determined. Okay. Now tools and methods of valuation. Obviously we will see multiple methods of valuation in this chapter, and the main objective of any valuation model, of any valuation method, is to determine the true value of the company. Okay. Now very important is just a concept called as financial modeling. Valuation involves financial modeling. Sir, what do you mean by the term financial modeling? So what happens is, tell me, I'm asking you a question, whether financial statements of the company and valuation is same. Is financial statements of the company and valuation same of the company? Answer is no. Obviously, in order to find the real value, you look not only at the past aspects, but you also look at future prospects. Okay, that is called as financial modeling. Financial modeling is taking into account both past activities as well as future income. Okay, so and obviously applying multiple methods to valuation, which one to use, etc. will be done. One important thing is financial your valuation is a subjective concept. It differs from person to person. Each person might use his own method, must do his own procedures, etc. Now, what are the motives for valuation? Why would you want to do valuation? So they have bottled it down into three categories. One is financial, business, and behavioral. So three categories of motives to do a valuation. The first one is to determine the financial worth, whether it is worth financially to enter into the transaction. Second, whether I try to quantify the benefit. Maybe I'm trying to quantify the section 72A, which is about taxation benefit, or whether I'm planning to do asset stripping. Asset stripping means what? I sell the assets for profits or gain. So I plan to take the asset for 10 and sell it at 15. So this is whether that is the objective, where it is purely monetary reasons. The other reasons could be business expansion or business diversification. Okay, that is a business related reason. So why am I doing a valuation of the business? Maybe the purpose for me, the motive here for doing a M&A is entering into expanding my business into a new territory. Or I could see that, listen, I would want that, listen, my company has X weakness and that company's strength is that. So I don't mind paying more. I need that strength, so I need to take over the company. And behavioral could be personal ambitions, personal grudges, that I want to take over your company for whatever reason. You had harassed my father, so I will take over. So these are random, any ambition that could be there. Okay, now need for valuation of a business. Okay, now what does it mean? So first thing is, why would you want to do a valuation? Now, as we saw in the earlier chapter also, everything, if a merger or amalgamation is going on, or if some company is investing, some investor is investing, he will do a valuation of the company and then make his investment decision. The next thing is financial reporting. Okay, so sometimes it is required to value certain shares, etc., as per law. Estate planning, if brothers want to divide, they will say 50% of the assets you keep, this much I'll keep, so that is done. Shareholders dispute to determine operation mismanagement, section 241 to 246. Okay, any litigation goes on and they are telling to do a valuation, or any strategic business reasons. Now situations requiring valuation, similar things they have said, all is covered. Okay, investor, if we are making public shares, JV, open offer, you want to purchase some shares of section your 241 to 246, conversion of your debt into equity, so again you need to do valuation. Okay, required under law. Now factors influencing valuation, so this also earlier we had done, and in the exam they had asked you what are the factors influencing valuation. Now you have to say that valuation is a complicated process. Okay, and the value of the company is determined on past as well as future earnings. Now obviously, to determine whether the future earnings are reasonable, calculations are done properly, you require a registered valuer. Now a registered valuer will look at multiple things, and multiple things can affect the valuation. For example, if your company is extremely into debt, or if a company has a good PE, or if your company, we look at your market price, what all things they will look. So the debt equity ratio, the growth, the customer base, the area of operations, financial statements, litigation if any. Okay, I will also look at the voting aspects, whether it's a good dividend paying company. I'll look at the growth rate, I'll look at the voting rights, past history of share price. I'll look if the promoters have taken a lot of those shares, special differential voting rights, then I would not want to value it well. So all those factors you will look. Now preliminary steps in valuation, very simple. So this general stuff they are telling, that what is the initial things that you will do. Okay, so business valuation involves analytical and logical analysis of not only the past but also the future attributes of the company. So very good English they've used, that a valuation involves analytical and I want you to write this in your exam. Okay, so a business valuation involves analytical and logical analysis of past and future prospects or attributes of the company. The preliminary study of valuation as of the following aspects. So again, further they have told you. So all these 3 points you can add up. Reason of valuation, whether it is listed, unlisted, the PE, the competitors, the technology, the discounting rate, all these factors will be seen. Now this chapter we will mainly be seeing the methods of valuation. So initially they will give you some method and they will repeat it again in the chapter. So just I'll go faster here because in depth it will come later. Just remember your market approach. Market approach means you will look at the value of similar size companies. So if a company has similar customer base, similar revenue, similar every aspect, okay, let's say there are two identical companies and one company and the same competitor which was of the same kind has been valued at 2 crores. So we will say that on basis on market data, even your value is 2 crores. So you determine the value based on market data or any past transaction. Income approach, I want you to write it down. Income approach is use the DCF or the intrinsic value method. Net asset asset approach means you do the net asset. Assets less liability is your net assets. Multiple based approach. Now multiple based approach is something new. Let me tell you what it is. Okay, so market is important. Multiple based approach, once and for all I'll explain. For example, okay, let's take this example that okay, now if I'm looking at the PE ratio, earnings or sales, okay, so I'm looking at PE ratio. Have you heard of the term PE? PE ratio, PE ratio, or let's keep this only, okay. Now understand, I'm looking at certain multiples that this is the company that I plan to value and this is the industry average or competitor, industry competitor. Now imagine if the industry's competitor price to sales ratio is 10 times. Okay, that means when the sale is 1 crore, okay, the value of this company becomes 10 crores. So if the competitor or the industry average is saying that you have that the industry gives a 10 times multiple to the of the sales as the value of the company, means whatever is the sales, if sales is X, value of company will be 10x. So similarly, if I find that this sales of my company is XYZ is 1 lakh, so according to applying the market comparable method, that they will say that a market multiple is 10 times whatever is your sales. So just let me simplify. As per market comparable, you will look at an industry average, a industry practice. So if the industry is practicing that the value of company is 10 times of sales, right? So then if I want to value company X and I find that their sales is 1 crore, so automatically I know as per applying the market multiple is which is 10 times, your value of your company becomes 10 times that is of your sales, that is 10 crores here. Simple. Okay, so what did we do? We did applied a multiple to the to determine the value. So in this method, a financial ratio or multiple derived from certain comparables and industry averages is used. Okay, the choice of this method depends on various factors. Why did you do it, which industry you're picking up, data you're getting, and similar circumstances. Okay, remember this is not an exact valuation that you ever get. It is not an exact science, but it is based on an approximate science that approximately this should be the value. No person can say this is the exact value of the company. Okay, so professional experts are there. They, after in-depth research, they give the value of the company. Now same thing they will repeat. Now valuation we have done. Now they've just said for merger. Now valuation principles and techniques we've done. We did valuation techniques and methods. Now for merger, now same thing, same headings, they are going to repeat it again. Comparable market analysis, I told you. that you use techniques involved using a comparable company in the same industry and using a price to sales. I gave you the same example, or price to earning, and basing on that you determine the value of the company. Then the income approach. This was the income approach. Sir, what was income approach? Where the discounted cash flow method is used. Then synergy analysis, just to identify how much gain the combined entity will get. Okay, so how to define synergy? Where the aggregate value, so just write it. Normally people understand synergy and they always give this lame little example of 2 plus 2 is equal to 5. But that is not the definition of synergy, right? No doubt it is right. 2 plus 2 is 5. 1 is the synergy amount. But to explain it in words, English, how do you explain? Where the aggregate value of company is greater than the individual, or we could say this line, that the combined value of companies is greater than the aggregate of individual companies. So when I add up two companies, it's coming to 2 plus 2 is 4, but the combined entity is coming to be 5. This is called as a synergy. This synergy, why you are getting this extra? So this extra is coming, maybe you are getting a economies of scale. Okay, economies of scale, or maybe now the brand value has changed, or market has expanded, or cost has been reduced due to the synergy benefits. Net asset value is nothing but assets less liabilities. Done. Market capitalization. Now this is simple. Market capitalization is market cap. How is market cap calculated? Do you know that? Simple. Market cap. How is market cap in companies used? So you use your market price into the number of shares. Market price into number of shares. So for example, if the market price of the company is 100 and there are 1 million shares, so the value of this company becomes 100 million. What is it? It's a straightforward calculation where you do market price times the number of shares. So they've given market price multiplied by the outstanding shares is the value of the full company. Okay. So one share is worth 100. So 1000 shares will be worth how much? Transaction multiple, same they have repeated as before. Now same thing they will repeat. Okay, so they keep repeating the same thing again and again till it gets into your head. So asset base, assets less liability. Income is, I told you, is your DCF method, discounted cash flow method, and market based approach is you use a multiple method. A multiple, as I told you, P is 10 times PS, that to determine the value. Now asset based approach, what do you do? Now pay attention, okay? So you do your assets less liabilities is equal to your net assets. Net assets, right? Now the thing I want to know from you is the price or the assets that you will do is as per market price, or it is as per historical price, book value price. Book value price. So when I'm doing this method, where am I going to use the market price of the assets, or I will use the book value price of the method? The answer is you can use both. So any can be used. So normally market price will give you a more accurate view. Now because real time building I'm taking real time. So if you do asset based approach as per the prices as on market price, it will be much better than using the balance sheet method. Okay, so asset based approach is assessing the value on basis of the net assets. Sir, how to calculate a net assets less liabilities? Arrive at the net asset. They've given a very simple baby example. Okay, what they have done is, if you see this example, net assets is equal to total assets minus the total liabilities. So they have written down the total assets here and the total liabilities has been given. So when you take simple little calculation, if we do, what is it? 16 minus 6.5. So 9.5, right? So let's see. Is your 9.5. Baby example, nothing, just subtraction they did and closed it. Okay, same example here also. What did they do? They took the total assets and they subtracted with the total liabilities. So again, if I go, it is 12.5 minus 5. So 7.5. So you come here, it is 7.5 is the net asset. So simple minus they have done directly. Okay. So just to show how easy it is. Now income based approach. Just a second. Now we are doing income based approach. Okay. Now income based approach means what I had always told you all, DCF method. Okay, sir, what is DCF method? Here you take all the future cash flows and inflows and reduce it to present value to determine the value of the business. Okay, future cash flows are brought to discounted through a discounting factor, PV factor. Market capitalization method, same thing when I tell you, they use the market capitalization method, that is the market price. So you can use methods for income based. Main is a discounted cash flow method. Rest all you can write. They just told you here. The ratio method, the multiple method. Okay, they've given you. Now market based approach. Now what is a market based approach? Pay attention that the similar. So basically you take a past transaction. Okay, you get it through market data. So for example, a similar sized company has been sold in the market for 2 crores. Has been sold with a value of 2 crores. So your value is also 2 crores. What did we do? We looked at a similar size business which changed hands, and that becomes your value of that company. Okay. Even you might not get exact same businesses, but even similar size businesses enough. Okay. So here they are telling, like I give you the example of real estate. Your house is of how much? Whatever is your value, all your flats in that building of having the same carpet size should be among the same pricing only. Types of market method is transaction method. If you look at a particular transaction which has gone, or if it is publicly known, then you look at that figure. Real estate example I gave you. Okay. Recent M&A. Now backsolve method. Now imagine what is a backsolve method. If you see Shark Tanks, what do they say in the Shark Tank? That the previous round that I have done at a valuation of 2 crores. So this becomes the benchmark. So a backsolve method is a recent equity transaction with an unrelated investor, which gives me the value of the company. So you say that the last round was done at this much. So we know that your value is at least 2 crores. Okay. Now again, discounted cash flow method, it was called as your income approach, income method, same thing. Okay. How to do it? Where if you see the simple calculation on how to do discounted cash flow method, okay, sums are done separately. You can either join the dream badge and get the sums, where or Samina ma'am will be taking the sums. Right now I'm not taking the sums at all. I'm completing everything else. So let's say we are doing the DCF method. Now pay attention, how do you calculate the form? What is the format? The discounted cash flow method, also called as NPV method. In executed we are done. So you write the year 1, 2, 3, 4. Then you write the inflows. How much inflows are we getting? So in this year, how much you're getting, etc. 1 lakh, let's say I'm getting in every single year. Okay. Then you put the PV factor. PV factor, discounting factor is 10%. Then each of these figures will be discounted at 10%. And let's say when in the end you sell the asset, you sale of asset is there. So when you sell the asset also, you must be getting some salvage. So that will also be an inflow. So you will discount that also you will find your PV inflow. So all you'll get the 0.91 etc. Multiply this, add it up here, you'll get a PV inflow less your present value of outflow is equal to your net present value. Okay, or just remember that this is the present value of the company. Okay, so all this will be multiplied. Okay, and then you will add it up all of your, you'll get PV value of inflows. Now see what all we did. We wrote down all the inflows, we wrote down the discounted factor, we wrote the salvage value, and that's it, done. See this, that what all did we do? In income method, we wrote down the future cash flows, future inflows, how much we are getting. We wrote down the discounting factor, PV factor. We wrote down the inflows, the terminal value, the salvage we wrote. We found the present value. Sensitivity analysis can be done. Sensitivity analysis means maybe in a good time we get XYZ, we factor in all the probabilities also, assumption that maybe in a good situation, normal situation, bad situation, what all will have. Okay, so those also factors will be kept in mind. Okay, now we see valuation under SEBI SAST. This I think we know regulation number 8. The method is there, okay, of calculating the offer price. Even in delisting they say you have to follow regulation number 8 only. Okay, then we come to slum sale. Mark slum sale as very important, very important. Okay, in your definite question of slum sale will be there. In your part A also slum sale has been covered in depth. Here it is only small. So remember what is the definition. Section 2 subsection 42C of the Income Tax Act defines slum sale. So in slum sale what happens, the company is sold on a lump sum price without assets being given individual value, without assigning individual values. So if an entire business is bought, so you did not give value to individual assets, right? So selling the business on a lump sum basis is called as slum sale. So that is done. The taxation will be as per section 50B. Okay, 50B is about capital gains. So capital gains will be calculated depending on whether the assets were held for long term, then it will be LTCG. If it is short term, then STCG will be there. In slum sale, what all is there? Assets are sold as a whole for a lump sum consideration. Prices are not assigned individually. Okay, and section 50B is there. And now capital gains tax will be applicable. GST is not applicable. So GST is not applicable to slum sales. Okay. Then came demerger. Now demerger is also given in your tax chapter 1 only, where you have to remember the definition is given under section 2 subsection 19AA of Income Tax Act. It says that when a company is being demerged, it is tax neutral. What does tax neutral mean? That it is no capital gains tax will be levied. Sir, what does it mean? Demerger. So demerger, first the meaning means a separation or a division. So means a division of a business unit from the company is called as a demerger. Let's take a classic example. Okay. So when we let's take a example. Let's say this is Reliance Industries. Now what happens is Reliance Industries had Jio in its segment. They demerged Jio and they made a new company called as Jio Financials. So Jio was first a subsidiary of Reliance that got demerged. This got demerged. Okay. So now what happens is a shareholder here. He was first holding shares in Reliance. Now he will be holding shares in Reliance and Jio. Okay, because he's got split. Let's say the valuation of this company is 100 crores. So, and each division was equal. So Reliance value would be 33.33. So this value, this Jio Financial, you will be having 33.33 and this will be 66.67. So what happened is if a person's company got split, so the new company will also allot me, and this company which is now demerged will have lesser valuation. Combined, you will have the same value only. So obviously it is tax neutral. No capital gains will be arise because you didn't sell it to third party. It is just that you had all the money in one pocket. Now you have 50% in one pocket, 50% in another pocket. So your value remains the same. So it is not a gain for the purpose of tax. Okay. Then they said principles and techniques of reporting. Now, principles and techniques. First thing is, as a business valuer, it is your job to make a valuation report. Now, there's a company secretary will make a secretarial audit report. Similarly, if a valuer is there, he'll come and value and he'll give a report. This report will come is an exercise he will do after observation, inspection, analysis, and calculation. So he will look, observe the assets, analyze, do some calculations, etc., and then apply certain assumptions of future value. This is called as basis of value. Sir, what is basis of value? Basis of value is basically certain assumptions why he has taken. He will give that. So that all will be done. He'll preserve in the valuation report what all information will be given about the purpose, why he has done, conflict of interest, which method he has used, any kind of assumptions taken, etc. Okay, all these information will be put in. Then relevant valuation and swap ratio. Now obviously swap ratio is normally, let's say if I have company A is there and it is merging with company B, and now we have company AB. So all the shareholders of A will now get shares of AB. All the shareholders of B will now get shares of AB. But how much shares will be going will be determined on the value of the company, that this company this much value, this company this much value, this company this much value. So the swap ratio will be determined looking at the valuation of the company, whether it is 1:1 or it is 1:2. So how much it is there will be determined by the chartered accountant. All the calculations etc. will be shown separately. Okay, in your sums you can do it, don't do it from your sums. We have covered everything. Okay, so with this we have completed the entire chapter as well. Thank you. Clear till here everyone? Yes or no? So we have completed. Okay, this has been knocked off and completed. So this is completed. Happy? Yes or no? So 20 marks in your pocket. It is done. Clear everyone? Okay. Done? Yes or no? Everyone's with me? Now we will be starting with another topic, which is your IBC code sections. IBC code sections. Okay. So are you all ready? Yes or no? In the chat box. Excited? Valuation we have completed and now we will complete. Okay. Gautami, great. What about others? In the chat box. Now after the break, we will start with, as I told you, the Bare Act of IBC Code 2016, where all these chapters of insolvency, your open book will get covered. Okay, so we will start. We will take a lunch break or dinner break actually, and come back. So we'll return back at 11 and complete it in a quick manner. Okay, so we return back at 11 p.m. and we complete and knock off this chapter. Okay, so till then you can revise all the topics or insolvency part and then we will cover. Okay, so that is it guys. Divya, great. So I will see you all back after some time and we'll cover. So 11 p.m. we return. Okay, so maybe in a fast track manner, in 1 hour I will complete the full IBC code, all the sections. Okay. Guys, am I audible and visible? We'll quickly start and finish off. Yes or no? Just in the chat box, am I audible and visible? GTG in the chat box. I'll make this subject really simple for you. Okay. Thank you so much, Rini. Always nice to hear from you. Gautami, great. Okay. What about others? Please tell me. So there is something special that I've prepared for all of you all, where I'll give you a full overview of your entire IBC code. Gautami, great. Let's begin. Okay. Now, so I'll tell you what I have planned. Okay. And this particular sheet also I will be sharing with you all. Okay. So this you can take a print in your examination and go. Just give me one second. IBC code 2016. Just 2 minutes. Okay. Okay. Let's begin. Okay. Wolf, Ashwarya, Anju, Gautami, great. Let's begin. So just one thing is, this entire sheet that I have prepared, I will be giving it to you all. Let's begin. Hi. So we begin with our Insolvency and Bankruptcy Code 2016. Now this will be helpful to you whether you're in old syllabus or new syllabus, because ultimately you have to study Insolvency Bankruptcy Code. Also, it is not only helpful for your CRVI, it is also important and very necessary for your open book insolvency paper. So let's begin. This sheet I will be sharing with you all on our website, Jahangir Tutorials. You can go ahead and download it. I will be doing it after this session gets over, and you can get access to this. It is highly advisable to get it printed and even browse through before going to your examinations. So let's begin. The Insolvency Bankruptcy Code 2016. So what is this code and why was it important? So very first thing, keep noting down things which you will quote in your exams also. Okay. So IBC code is a comprehensive law which talks about insolvency and bankruptcy in India. So insolvency and bankruptcy, insolvency could be for corporates and bankruptcy is generally for individuals and partnership firms. Okay. Now, for the IBC code, they had constituted a special committee called as a BLRC committee, or the Bankruptcy Law Reforms Committee, under the chairmanship of T.K. Vishwanathan. All this we will write in the exam. This is the beautiful introduction, that IBC code, insolvency and bankruptcy. Insolvency is for corporates and LLPs, whereas bankruptcy is for partnership firms and individuals. So this is for firms and individuals, and the same term we use for company or LLP, we use the word insolvent. For individual, we'll use corporate. So IBC code in India is a comprehensive law for insolvency and bankruptcy. It was brought in through the committee, BLRC committee, okay, and under the chairmanship of T.K. Vishwanathan, okay. Now, again, I want you to quote it in the exam, that what is the object of the act or the preamble of the act. Okay, so we will definitely be writing it, that the main objective of the IBC code is, you will see the word liquidation is not there. The main objective of this, even when a company is coming to for insolvency, we will try to revive it. Okay, so the main act, IBC code, is made so that in a time bound manner. So they give you that particular IBC matters will get over max in 330 days. So the tenure they have told is 330 days. It has to mandatorily get over the entire revival of the company. The main objective we want is that in business, obviously there is risk. So we want to promote entrepreneurship, okay, and establish IBBI. Sir, what is IBBI? It is a board which contains, which covers all the laws, all the amendments, all the authorities are covered under the IBBI. So IBBI is your authority, just like SEBI is for stock markets. All insolvency laws in India and control of all the IBC authorities are by the IBBI. Sir, why was this Insolvency Act passed in the first place? Why did he not continue with the older acts? So basically what happened is, this is the time to resolve insolvencies. Now see, this is the time. So you can write this, that the main reason why they brought in the IBC code 2016, in 2015 World Bank stat see what it was there before the act. The time to resolve any insolvency, if any insolvency happened and the creditor took the company to court, in UK it used to get over in one year. Matter used to end in 1 year. In Brazil it used to go in 4 years. In USA it used to go in 1.5 years. Matter is closed. But in India it should take 4.3 years for one case to get over. So then they said we want a time bound case to close the matter. Not only that, we saw the recovery amount. What is this? If you go to see the recovery amount, the low recovery rate of 26.5 means what? For every 100 rupees, okay, 100 rupees lent, what happened is, imagine in USA they could recover, the creditors, if they were 100 rupees due, they could recover 81. Okay, in UK 85 means if they have given a loan, they get it back. However, in India the stats was only 25. So looking at the low recovery rates that we had and the time to file cases in for the creditors, it wasn't very country where we had efficient system for recovery of debts. Then they said that let's do something, we need to make our country better. So what did we do? We introduced the IBC code 2016. Sir, beautiful. We understood the object of the act. It is to promote entrepreneurship. It is to establish IBBI. It is to revive and restore the company, etc. Now, IBC code 2016 has in total 255 sections. So it's not a very big act. It is 255 sections divided into 5 parts. Now, from exam point of view and from your personal point of view, the most important part is your part 2. Why? Because it talks about insolvency of corporates. So when a LLP or a company is getting insolvent, the entire process is covered under part 2 of IBC code 2016. Now part 3 talks about individuals and partnership firms. Okay, individuals and partnership firms, and part 4 talks about the authorities and regulators under the IBC code. Okay, so part 1, 2, 3, 4. What are the authorities? We will see in some time. Okay, so here when we go to part 2, 4 to section 77A. So now let's look at the section list. Even in your part 2 of your IBC, from that also we need to know chapter 2. So this I want you to quote in the exam. Part 2 chapter 2. Can we quote that much? Part 2 chapter 2. Part 2 is about corporate liquidation and resolution of corporate persons. And chapter 2 talks about CIRP, and it is from section 6 to section number 32. If we could not do revival of the company, then the very next chapter is there that we will go ahead and liquidate the company, section 33 to 54. So this much I want you to quote. Part 2, chapter 3 and 4, section 6 to 32A and section 33 to 54. All this I want you to quote. Okay, that's it. Now let's see. There are certain form numbers also I want you to write and quote in your exams. Okay, so now remember that whenever there is an insolvency, case can be filed. For example, a company is becoming insolvent. So who will file the case? Obviously the creditor will file the case. Now financial creditor is a person who has given a financial debt or a loan. Financial debt means what? Where it is shown by interest. Delay is shown by interest. Okay, so he will file in form 1 section 7. So sir, form numbers, yes, you have to quote, note it down. Now second is operational creditor. Operational creditor is section number 9 and form 5. So what is form 5? Form 5 is basically when a operational creditor. So who is a operational creditor? Is a person who is given an operational debt. Sir, what is operational debt? A debt is basically operational debt is where money demand is coming from basis of good supply of goods and services. So for example, if I have supplied goods to you and you have not paid the money, I am a operational creditor. If I have given you services such as salary or for employee also, so they will be operational creditors. So two kinds of creditors are there recognized under the IBC code. Financial creditors, that is your lender of money, loan, and operational creditors, those who have given services of goods. So form 1 and 5 we will write it down. All I want you to note down, okay? And form number 6 is the corporate debtor can also file a CIRP process for insolvency process. Sir, why will he file? Corporate company himself will go and go to the government and file. Yes. What happens is the corporate debtor will go and tell the government that listen, in the Object Act it is written that you will try to revive me. Please revive me. So the section numbers are sorted. Okay. Section 7 is for financial creditor and will be in form 1. Form 5 will be for operational creditor and section number 9, and form 6 is for corporate debtor, section number 10. All the sections I'll make you learn, don't worry. Okay. Now, as we saw in your part 4. Sir, what was part 4? Part 4 is about authorities and regulators. Authorities and regulators. We are seeing that. So, which are the authorities under your IBC code 2016? First is the adjudicating authorities. It is the adjudicating authority. Adjudicating authority means what? If an insolvency case will go where? If it is with respect to a company, it will go to NCLT, and if it is with respect to an individual or partnership firm, that is a non-corporate entity, entity not having separate legal existence, they will go to DRT. Appeal from NCLT will go to NCLAT, and from there it will go to Supreme Court. In DRT, it will go in appeal to DRAT, DRAT, and then it will go to Supreme Court. So these are your courts which they have given. And now coming to your other authorities. So your first and the most important is your IBBI, Insolvency Bankruptcy Board of India. So what it is basically a regulator for insolvency matters in India. It recognizes all these three authorities. Okay, it has the powers of a civil court or for matters of for summons, witnesses, etc. They recommend the entire laws, etc. So this is done. Now we come to insolvency professionals. After completing CS, after doing your CA, after doing your CMA, you can register yourself with the IPA. IPA is basically just like how you have ICSI. There is a ICSI IPA, ICAI IPA, and ICWA IPA. So these are all our institutes have registered themselves as a Section 8 company and are conducting insolvency examinations. Once you conduct an examination, they will give you a membership and you will be a registered valuer. If you do something wrong, professional misconduct, then they will suspend or cancel your license, reprimand you. So all those things what ICSI does on us, IPA will do on insolvency professional. Insolvency professionals are those who will be appointed to revive the company and prepare certain resolutions plan. And the last authority that is there is called as information utility. Sir, what is an information utility? Information utility is an authority or is a body that will collect and collate the information of the corporate debtor and his assets. What happened is Vijay Mallya, he ran away from the country. The creditors didn't even come to know. So now they have made a special authority. They have made a special body which job is to keep track of all the creditors, of all the debtors and their assets, that they do not end up alienating or running outside India. So it has all the information about the debtor and his assets. So what is the entire flow of the chapter? What is the entire IBC? What happens here? Okay. So let's see. Insolvency will be, first there has to be a default. A company which is completely into profit, not making any default, cannot come before IBC code 2016. Clear? If everything is good, a profit making company, a company which has never made a default, can never come before IBC code because it doesn't look like any problem. The entire scenario, the entire process starts from a default, payment of default. So there must be the creditor, he must not be able to pay the money. if he has not been able to pay the financial creditor, he couldn't pay. Even one EMI is bounced, the financial creditor can go directly and file a case to the authority, NCLT. Similarly, on default, if he himself felt embarrassed, corporate debtor, he knows that his future is little doubtful and he requires some help from NCLT, then corporate debtor can also himself go to and initiate the CIRP process, that is corporate insolvency resolution process. So company is getting insolvent, we will try to revive it, that is the process. Okay, so corporate debtor will go in section 10, financial creditor will go in section number 7. Sir, where is section 8 and 9? So that is for an operational creditor. So imagine a supplier of goods and service. If we have defaulted to make a payment to him, he cannot directly go to NCLT. He has to give a demand notice, okay, under section 8, and then in section 9 he will file a case to CIRP. So demand notice is given under section number 8, that he has to give a legal notice that better pay me my money, otherwise I'll go and complain to NCLT. And demand notice form also, please note, section number 3, form 3, okay, is, so I want you to remember these form numbers and quote it mandatorily in your examination, okay. So not many students are going to write, but you will write because you are my student. Form 1, 3, 5 and 6. Form 1, 3, 5 and 6. Financial creditor, operational creditor filing a petition, demand notice is in form 3 and corporate debtor files in form number 6. Okay. Now, once they file an application to NCLT, okay, once they file an application to NCLT, then what happens? Pay attention. Then NCLT gets 14 days time to admit the application. How much time does NCLT get? 14 days time to admit this application CIRP process, and they will then do 3 things. Okay, they will appoint a IRP in the matter. They will say, okay, this person is the interim resolution professional. Interim resolution professional will be appointed. This interim resolution professional will go ahead and make a committee of all the creditors. He will find out who all money is pending. He will make an entire committee that will come, and then the committee of creditors will then form and appoint a RP. Sir, process again. So you file an application, goes to NCLT, then NCLT admits the application. After admitting the application, NCLT is not going to do the work. They appoint a IRP. IRP will make a committee of creditors, and that committee of creditors will then say that whether they want to continue with the interim guy or they want to appoint a new RP. Okay, sir, after the RP is appointed, what will happen? Now the RP will invite resolution plans. What he will do? He will tell various resolution applicants. He will tell various investors. The investors are called as resolution applicants. That do you want to invest? Are you ready to buy? This company is getting sick. It has a good brand name. You can invest. We'll give you a discount. He will try to sell. He'll try to invite various plans for revival. If we receive a plan, well and good, the plan is approved, the matter will be resolved. Okay, if the plan could not be, we didn't receive only any plan, then we'll go for liquidation. So if I summarize, what happens here is application is given to for CIRP. Then CIRP appoints a authority, IRP. Then IRP will form a committee. The committee will then appoint the RP who will invite resolution plans. If we get the plan, matter is resolved. If we don't get the plan, then we will have to proceed for killing the company completely, which is called as liquidation. Okay. Now, as I told you, sections are important. So, chapter 2 is important. Okay. Chapter 2. Very, very simple. Which sections I told you is important? Section number 7. It is where the financial creditor files a case. Initiation of CIRP by financial creditor. The corporate the operational creditor cannot directly file. He goes in section number 8. He files in section 8, he has to give a demand notice. If in demand notice within 10 days, we have not received the money or we have not received any reply, then he will go in and file a CIRP application in section number 9. 10 says corporate debtor himself goes on and files a case. 11 says who cannot file an application if CIRP application was already pending or it is already dismissed earlier, so they can't go. Time limit for completion of CIRP. So very simple. 180 days plus 90 days. If within that much also not, then you get more 360 days. So in total, the entire CIRP will get covered over in 330 days. Okay. Now, moment the CIRP application is accepted by NCLT. Moment it is accepted, three things will happen. Now, pay attention to this. Okay. Now, moment NCLT picks up the application, then three things will happen. For example, these people, they came and they ran to NCLT, say that please help us revive. Any of them. Financial creditor under section 7, in section 9, this guy, what's his name? Operational creditor, or in 10, that corporate data. Once he comes to NCLT admits the application, automatically three things will happen. A moratorium period will happen. Okay. A public announcement will be made, and a IRP will be appointed. Three things happen. So first is a moratorium. Moratorium is now no case can be filed, no suit can be filed, no enforcement order can be filed against the company. A public announcement will be made by IRP will come. IRP will be appointed by NCLT, and he will file a public announcement that whoever's claims are there on this date, you will come and give the claim. I'm making a claim list. I'm doing all this to prepare a committee of creditors. Committee of creditors. I'm constituting the committee of creditors. So NCLT appoints IRP. I told you IRP will come. What is his job? His job is first to constitute a. We'll see all these basic things are there. That he will, all the powers of the directors he will have. Okay. He will be there till the committee of creditors select the RP. Once the committee of creditors are there, his job is done. Duties of the interim resolution professional. So IRP will come. His job is to make a committee of creditors, figure out who is the financial creditors. Okay, all of those he has to collect all the list, etc. All the persons are required to give cooperation to the resolution professional, and in 20, management of the operation will be done on a going concern basis. Sir, what do you mean by going concern? Even though if it is taken in CIRP process, doesn't mean that the company cannot function. Company's day-to-day operations will go on. Okay, no one can file any action against the debtor without the consent of the IRP. So moratorium is there, but that doesn't mean that the company will not function. Now IRP's main job is to appoint a committee of creditors. So committee of creditors will be formed with all the financial creditors. We will form a committee of creditors. They will have their first meeting of committee of creditors, and then they will appoint a RP. Sir, what is the committee of creditors? What will they do? They will appoint a resolution professional. Sir, what is the duty of a resolution professional? So the resolution professional's main job, is to prepare something called as an information memorandum. Sir, what is information memorandum? They will prepare an entire data about the company, how many creditors are there, how many issues are ongoing, all the assets of the company. Full information memorandum will be prepared. This information memorandum will be shared with investors. Okay, so investors can then give their resolution plan. Always remember, they don't call the word investors here, they call them as resolution applicants. So they are applying that they will revive the company, they will invest money into the company. So what's the main job of a resolution professional? The main job of a resolution professional is to prepare an information memorandum, to invite claims, and then settle the prepare a plan and then tell NCLT which is the final plan which has been accepted. So see, resolution plan, applicant submits the plan. So in section 29A, person not eligible to be resolution applicant. So they are telling you who cannot become a resolution applicant. Sir, what do you mean by a resolution applicant? Investor, who are not allowed to be investors into this business. A plan will be prepared. Plan has to be approved by 66% of the committee of creditors. Okay, they will tell you how many people will approve the plan. We'll just check the percentage. Okay, and that is it. Okay, if by 32A everything is not fixed, then the company will go into insolvency. So if you go back, what is the procedure? That application is filed, CIRP. Moment CIRP is filed, accepted, moratorium period will be announced. Moment moratorium period is there, IRP is also appointed. IRP will prepare a committee of creditors. The committee of creditors will appoint a resolution professional. This resolution professional will invite resolution applicants, they are investors, to give their plan. How do they want to go ahead? And after the approval of the plan from the committee of creditors, they will give it to NCLT to close the matter, and then the revival will happen within 330 days. If not, then the liquidation procedure will start. Clear? So let's begin with giving you the markings also. First, okay. First, section number 1. This act applies to whole of India. Section number 2, as and when we come, I will tell you. Now, interestingly, section number 2 does not talk about definitions. Normally, always section 2 talks about definitions. But in IBC code, section 5, okay, section 79, okay, and one more section is there which talks about definition. And that is section 3. Section 3, 5 and 79 talks about definition. So what is section 2? Section 2 says this act applies to when? So this act applies to companies, as we did, na, company, LLP, individual and partnership firms. Okay, it applies to all of them. Simple. Now comes the definition. When we do that, we will come to, in the chapter, we will come to know. Now we see section number 4. So what is section 4? So it says that when can a case be filed in NCLT? The application of CIRP process. For a CIRP process, remember that the minimum default size is 1 CR. So the minimum default, okay, size is 1 crore. So central government by a notification says that a default of higher value of shall not be more than 1 crore. They will specify. So they have told 1 crore is the final figure, okay. Beyond that, they cannot put that default amount. Now coming back to the definition, I told you 5 talks about the definitions. Section 6 says who may initiate CIRP process. I already told you that 3 parties can initiate insolvency process given in section 6. So creditors, financial creditor, operational creditor, and the corporate debtor himself can also initiate a CIRP process whenever there is a default. So default means what? Even 1 rupee default is allowed. What do you think? And does the default amount include the interest amount, or only the principal we are counting? So the answer is a debt, whether whole or any part or installment. Any part or installment is not paid. Okay. So obviously it means any part of the debt, and debt includes interest. So even if you not paid 1 EMI, CIRP can be started against you. Second, provided it is 1 crore threshold should be there, okay, then only it will be there. Now, as we did initiation of section 7. So how does it start? Section 7 is about moment the default is there of 1 crore or more, then you will anyone can file an application. That here in section 7, the financial creditor will file a case, and NCLT will either accept or reject the application. Okay. Section number 8, what does it talk? That operational creditor may on default deliver a demand notice. So operational creditor cannot on default, he cannot file a case. He has to give a note. He has to give a demand notice, and only the demand notice will be in 5, in 3 form number. Then he will have to wait for the response of the corporate debtor for a period of 10 days. So the corporate debtor shall within 10 days of receipt of the demand notice bring to the operational creditor 2 things: that existence of dispute or proof of payment. So he will say either I have made the payments, either electronic transfer, or he will say that why should I make the payment, goods were defective. If there is nothing like that happening, then obviously in section number 9, the CIRP process will be initiated by the operational creditor. Okay. So after the expiry of 10 days, the operational creditor does not receive a proof of payment or notice of dispute, then he will file a case before NCLT. He will file in form number 5. Okay, with all the details, etc. A operational creditor must individually meet the 1 CR threshold under section 4. Unlike financial creditors, operational creditor cannot combine their joint claims to file a joint application. Now remember one thing, that if there are 3 lenders, okay, now to touch that 1 crore threshold, 2 financial creditors are there. They have, each of them have given 60 lakhs. Individually they cannot file a case, but they can club themselves. Financial creditors are allowed clubbing joint application, but operational creditors are not allowed to file joint application. They have to individually meet the 1 CR threshold, because obviously the government is giving more preference and recognition and importance to financial creditors. Important point. Then we come to section number 10, where the corporate applicant himself, company himself realizes that he has defaulted. He will immediately run to NCLT to get moratorium stay, so none of his assets can be there, and NCLT will appoint a resolution profession to revive him. Okay, so he will file an application in form 6. Learn the form numbers in the beginning. He will give all his proof of default, and the NCLT, moment they accept it, within 14 days they will accept or reject. From that date the commencement date will start. So one important line is there for all of them. CIRP commencement starts from the date of admission of application. For all of them, moment the NCLT accepts it, the CIRP process will start. Sir, what is it? That 330 days will start from that day. Okay, so that is why it is important. Now, person not entitled to make a application. Now, very sad, these people cannot do. Someone who is undergoing already CIRP, who is undergoing PIRP, who has completed CIRP in the past 1 year, or who has got a plan approved in the past 1 year, okay, 12 months. So all these people, they have already done all these revival things with them. They are undergoing liquidation already. So then, or they have violated the resolution plan. So all these people, either they are undergoing already, or they have just completed recently. So now we are not going to entertain all these sick people again and again to come to the court to revive them. Okay. Now, remember the time limit, section number 12. What is it? Section number 12 is the time limit to complete CIRP. So what it is, that within a span of 180 days, CIRP should be completed. If government wants, they can give a consent, they can give an extension of 90 days, further 90 days. So 180 plus 90, how much will it come up to? How much? 180 plus 90, 270, right? So within 270 days it should get completed. However, one more extension has been given, that more extension of 60 days. So if you add more 60 days, how much you get? So if I add more 60 days to this, then 330 days. So in total, the CIRP process has to be completed within 330 days. Now remember that last 60 days is not due to party's default, but if the court procedural delays are there, that is why that extra 60 days has been given. So remember, 70 plus 90 plus because after 90 they say no such extra extension will be given, but very next line they say that more 30 days, 330 days it should be completed. That 60 days is for court delays. Okay, so that you can write and close it. If so, here is your threshold, that initial period is within 180 days CIRP process should be given. Extension can be given if committee of creditors have passed a resolution of 66%, then a 90 days additional period can be given, and in total, including all the legal proceedings, it must conclude within 330 days mandatorily. Okay, now obviously comes withdrawal. So in 12A, if any of them want to withdraw, they can withdraw their applications also. Now coming to very important, okay, very important. So first thing is NCLT, let's say, okay, now note this down. NCLT admits the application. What does NCLT do? it admits application. Okay. Moment they admit the application, three things will happen. Sir, what? IRP will be appointed. Insolvency resolution professional will be appointed. A moratorium period will be declared. Moratorium period will be declared. Moratorium is like a stay order. Okay. And third, a public announcement will be made that this company is coming under this moratorium period. Now nobody can file a case against the company till we further order, till the CIRP process gets over. Okay. So now very important, section number 13, that the adjudicating authority, okay, after admission will do three things. They will declare a moratorium period, they will cause a public announcement, and they will appoint a IRP. Three important things will happen. Okay. Then moratorium. Sir, what is a moratorium? So moratorium is a stay order during which the no new suit can be instituted, no transfer or disposal of assets will be done, no creditor can enforce their security interest. Okay, recovery of property by owner or lessor cannot be done. Okay, recovery of any property from the owner lessor will not be permitted. Okay, however, essential supplies. So when we say everything will stay, that doesn't mean the business will also stop. Essential supplies, etc., shall not be terminated, suspended during moratorium period. So whatever is needed will on go. Okay, on a going concern basis. Now, when till when moratorium will on the duration of the moratorium? So obviously till the resolution plan is approved or company has gone into liquidation. Okay, under section 33. Now section number 15, what does it talk about? I told you, one is moratorium we saw. Okay, that no case, no enforcement, nothing can be done. Section number 15, a public announcement will be made that any they'll tell that this corporate debtor is under insolvency. This is the last day to submit your claim. This is your IRP. You can go and inform him. Okay, and they will also say that within 180 days we will complete this entire process. So be active. The third thing is IRP. Now, moment the IRP comes, his job is to first to find out whoever's money is left, who's pending, and they make a committee of creditors. So who appoints IRP? So financial creditors and corporate debtors have to mandatorily tell who the IRP is. Operational creditors may or may not give the name. Okay, so then the NCLT can either keep the IRP or they will ask IBBI to give an IRP, but there should not be any disciplinary action against the IRP. Common sense, they wouldn't keep anyone who has a disciplinary action going against them. Okay, now once that is done, then comes management of the affair. Now we're just seeing all with respect to this guy only, IRP. IRP will now have all the powers of the board of directors. All the powers of the board of directors have been suspended. So the board of directors automatically their powers have been transferred to the IRP. Now they will manage all the employees, everyone, every employee will report to the IRP just like they did to the BOD. The instruction of financial institution, the institution shall act on instruction of the IRP. So again, everybody, including the creditors, will now have to work on the instructions of the IRP. Now the powers of the IRP is to execute all documents, run the company, get access to all the corporate records, electronic records, comply with all the laws. Now it is his job to ensure that the company complies with the laws because all the powers of BOD come to him. Section number 18, duties of the IRP. What is the duty? So obviously his duty is to collect all the information about the business, prepare and collect and collate all the claims, and form a committee of creditors. Okay, now this committee of creditors will now decide the new IRP, whether they want an interim resolution professional to continue or they want to appoint a new RP. That new RP will then find plans, etc. This IRP only is there till the committee of creditors is formed. Okay, so everyone in section number 19, everybody has to listen to the IRP, cooperate with him, listen to his instructions, etc. Management of the affairs will be done on a going concern basis. He will have a right to appoint legal personnel, staff, amend contracts, raise interim finance, issue any kind of instruction to any employee, take necessary measures to ensure that it's a going concern. So IRP creates a committee of creditors. Now the committee of creditors, once the IRP is made, then they will decide the new RP, whether they want to continue or go ahead with them. See, the IRP collects all the claims and then constitutes a committee of creditors. This composition of committee of creditors, the committee of creditors shall comprise of all financial creditors only. If it is a related party, that person will not be allowed to vote. Okay. Now, this section number 21 is important. You can read it in depth also. Okay. All the access to the lectures are available in the Dream batch. You can go ahead and go through all this. Okay. We are just trying to complete the sections and try to memorize section form numbers which we can quote in the exam. Okay. Now, appointment of resolution professional. Once they are there, now I told you, committee of creditors, what will they do? The first committee of creditors meeting shall be held within 7 days of their constitution. Okay. They will appoint a RP, either as I told you, replace or continue the same guy. Resolution by the committee of creditors, they will pass a resolution to appoint a RP. Now the RP will be appointed. Section number 22. Sir, what will the RP do? Now the RP, here the revival process starts. The resolution professional is responsible for ensuring the CIRP process, that we get a plan and constitute. He will have all the powers of BOD now, just like the IRP had. Now he will have all the powers, all the information. He will conduct the meetings, etc. Okay. Now even operational creditors can attend the meeting, but they cannot vote. Okay. So all this also you have to read. Important duties of the resolution professional. So he will ensure that the assets are safeguarded. A proper list is prepared. He will see an information memorandum he will prepare under section 29A. So what is that? All the status of the affairs. Okay. Maintenance of the list. He will prepare presentation of resolution plans he will do. Let's see. 25. Okay. Rights and duties of authorized representatives of the financial creditors. Okay. Now just remember one thing, that financial creditors are there. Okay. Financial creditors who have extended a loan, etc. Even your real estate allottees, like for example home buyers, simple word, home buyers are also considered as financial creditors. Now home buyers might be so much if the builder has cheated you. So all of them, they can appoint a authorized representative to represent them. And or we have even debenture holders. So they are also financial creditors. Now so many debenture holders will not come. They will all appoint a authorized representative, and the authorized representative have to act according to the these people. Okay. Now replacement, if this resolution professional doesn't do a good job, he can be replaced, okay, by 66% votes. Now coming to approval of committee of creditors for certain actions, or certain things are there require approval. Now we come to preparation of information memorandum. Sir, what is the information memorandum? All the information about the company will be kept here. Now obviously this access to information, so shall provide to the resolution applicant all the details. Sir, information memorandum, you can understand from the name itself, it gives a full information about the company. Now understand what happens if we see the full process. First is financial creditor, operational creditor or corporate data, they file a case before NCLT. Okay, NCLT. Now NCLT will then appoint a IRP on admission. Then moratorium will be declared. And one more thing is a public announcement will be given. Okay. Now once that is done, the IRP will now form a committee of creditors. This committee of creditors will then will appoint a RP. this RP will prepare something called as an information memorandum. Okay. Now this information memorandum will be shared with resolution applicants. Sir, who are resolution applicants? They are investors who will submit their resolution plan. Okay. So who submits the resolution plan? Resolution applicants. They submit it to the resolution professional, and then once a plan is received, it will require approval of committee of creditors and the NCLT. Okay, and then the process will close. Okay, so here we'll have to give all the information to the resolution applicant, the investor. Only then he will invest into the company to revive. Now the thing is, who is not allowed? Common sense, if you're undischarged, insolvent, you're willful defaulter or a non-performing asset. So such person is not allowed to act as a resolution applicant investor into the business. Okay, then your plan will be submitted. Submission of the plan. Resolution professional will examine the plan whether it covers the resolution cost to be covered, ensure that the operational creditors are paid. Okay, the priority of claims, the waterfall arrangement is given in your section 53, whether that order is maintained. Okay, it should be approved by 66% of the voting rights, and then it will be approved by NCLT. So till now everything is approval of this plan is given in section 31. The authority, if satisfied, will approve the plan. So till now everything is rosy and everything. Okay, now the dangerous thing comes that if no plan is received, or 330 days are over, or if there is a violation, then we will proceed for liquidation. Okay, now liquidation is about selling the company. So now a liquidator will be appointed. The resolution professional can only become the liquidator, or a new liquidator can be appointed who will sell these assets. He will identify liquidation assets. Liquidation the asset means those assets which can be sold to recover money. You cannot sell off a personal jewelry of if a bank is being liquidated, they cannot sell the locker room thing which is just kept as security to you. Okay, so which can be taken to be sold, which cannot be taken, will all be there. Okay, so let's see. And then the money will be distributed as per the waterfall arrangement. So where the adjudicating authority, before the process, okay, now when they will do, if they did not receive a resolution plan, now we are seeing liquidation process. Okay, now this starts from section number 33, that we did not receive a resolution plan. Okay, or it has been rejected, the resolution plan. Okay, or the committee of creditors have said that they will pass a liquidate the company. 66% have said liquidate the company. Okay, so all these circumstances are there, which will lead to which will lead to liquidation. Now what will happen is, now when liquidation has been confirmed NCLT, then a liquidator will be appointed. Resolution professional can act as a liquidator, or a new person will be appointed as a liquidator. What are the powers of a liquidator? We all know, like we've always done, a liquidator, he'll take control of the assets, determine a valuation estate, and then end the company. Okay, so could be replaced. Powers and duties of the liquidator, section number 35, important, very simple also. Okay, now liquidator will verify the claim, take all the property in his custody, evaluate the assets, okay, take measures, carry on the business till it is liquidated. Then comes section number 36, very very important. Okay, section number 36, that the liquidator will prepare a liquidation estate. Liquidation estate means all those estates that will be part of the liquidation, or will be part of the sale. Okay, tangible, intangible, all property will be taken to be sold. Okay, the liquidator will have a power to access all the information as he wants, information, utility, etc. claims will be consolidated, verification of claims will be done, and they've given you three kinds of transactions. Just remember, preferential transactions, extortionate credit. So just remember, section 43 is about preferential transactions. Then we come to avoidance of undervalue transaction. So there is a undervalue transaction, there is a preferential transaction, and there is a extortionate credit transaction. There is a extortionate credit transaction. What is it? Let's see. Extortionate credit transaction. So when these three happen, the liquidator or any resolution professional can declare these transactions to be void. That means undervalue transaction has happened. So obviously there is a loss. So they will identify that who has done this transaction and declare it to be void. Extortionate credit transaction means extortionate means unreasonable credit transaction has been done with the objective of ensuring that nothing is given to the creditors to defeat the claims of the creditors. So this will also be declared void. Okay, and orders will be passed to restore the orders, repay the payment, etc. So these three, just note down, that is also important. Then we come to section number 53. What does section 53 talk about? The distribution of assets. The very first thing that's called as this is called as a waterfall arrangement. What it is called? Waterfall arrangement. Okay, what is waterfall arrangement and in which order it will be given? Priority of payment. First liquidation cost will be given, then workmen money will be given, they'll be in pari passu with secured creditors, then the employees wages. Now employees, not workmen, employees will be given for another who's 12 months who are there unsecured, then the government dues. So all this waterfall arrangement is that you should learn, important. Okay, and then in the end they will dissolve and get a dissolution order. After that the company will cease to exist. Okay, now it ends on section number 54, dissolution order. Section number 54 is dissolution order. Now pay attention to this, that a pre-packaged, now the government introduced something called as PIRP. What did they introduce? PIRP. It is from section number 54A to section 54P. So what is PIRP? How is it different from CIRP? So PIRP is specifically a very beneficial insolvency process given to the MSME, small and medium enterprise exchange. So can a non-MSME come for PIRP? Answer is no. What is the concept? We'll see later, but first understand that this is only and only for MSME. This is only for MSME. Okay, fine. Okay. Can MSME come for CIRP? Answer is yes. They can come for CIRP and PIRP. MSME have an option. Either they can go for PIRP, but PIRP is much better. And we'll see in which circumstances PIRP is possible. So in PIRP, what happens is the debtor stays in control of the assets. As compared to CIRP, what happens? The resolution professional takes all the powers of the creditors and then he sits with the powers. Takes all the powers of the directors and comes. Here what happens? Now let me explain. So here the PIRP I'm explaining. PIRP. In PIRP, it is only for MSME. Now the corporate debtor and creditor, they themselves have an agreement. They have an agreement already before coming to NCLT. They will have an agreement and prepare a base plan. They come to some agreement and they come to a base plan. So only if agreement could not be done, then the MSME will not be able to come for PIRP. They will have to go for CIRP only. So base plan is required based on agreement with both the parties. So they are not coming as a disputant. They both are coming to the government with a basic plan. Okay. So once you come with the base plan, the creditors, the corporate debtor can remain in control of company. Normally what happens in CIRP, you have to mandatorily come, all the powers of the directors go to the RP. This doesn't happen here. And normally how you have CIRPs for 330 days, this is for a lesser period. We'll see. Okay. So this is the entire difference between PIRP. MSME come, they make a base plan and they also get to stay, the debtor gets to be in control of the resolution. Debtor in possession means he will be in possession of the company only. And the entire thing will get over. Like how you have 330 days, here it is a voluntary process initiated and will be completed within 120 days. So that gets over CIRP in 330, this gets over in 120. So if you see section 54A, who is eligible for PIRP? Obviously, it must be classified as MSME as per the MSME Act 2006. One. Second, they have to come. Now they have to come with consent. Okay, consent of 66% of the creditors, and even the company has passed a special resolution. So both the corporate debtor and the financial creditor, they both have come to an agreement. So both of them have passed a resolution and they passed a base plan. Then everything else remains the same. The government will just supervise that this is completed as per the base plan. So the insolvency professional appointed shall prepare a report and a conformity of a base plan and file a report with the IBBI, with the board that listen, these both have come, they prepare a base plan, let's prepare and initiate PIRP where we'll try to revive the company. Okay. The same thing, the PIRP time limit, section 54D, that the PIRP shall be completed within 120 days. The resolution professional shall submit a plan approved by the committee of creditors within 90 days, failing which it will apply for liquidation or it will be terminated. PIRP will be terminated. So 120 days the full thing will get over and resolution plan will come within 90 days. So it's a fast track mode also. Okay. And then once PIRP is there, same thing. And your public announcement will be done. Our resolution professional will be appointed and moratorium will be declared. Okay. Rest everything remains the same. You prepare an information memorandum, etc. It's just the initial who stays in control. So the management of the affairs will be with the corporate debtor only. This is the most important. And one thing is, another differentiation is the RP shall constitute a committee of creditors within 7 days and convene the first meeting within 7 days of constitution. So what happens is, moment the RP is appointed, he will prepare within 7 days, he will prepare a committee of creditors. In the next 7 days, the committee will have their first meeting. Simple. Okay, all decisions will be taken by 66% voting share of the committee of creditors. They will prepare the base plan and try to give a final plan which has to be approved by 66% parties. Okay. So where two things, termination of PIRP, when PIRP will get over, where no resolution plan is submitted within 90 days or not approved within 120 days. So first they said the plan has to be submitted within 90 days and it has to be approved within 120 days. If this is not done, then we'll say that it has been terminated. Okay. So the first meeting is within 7 days. Okay, is within 7 days of the committee of creditors and constitution within 7 days of pre-package, the commencement date, the COC will be, so same thing. Moment the application is accepted, within 7 days COC will be appointed and within the next 7 days the first meeting will be held of this. Okay, with this. Okay, now, so what was it, that submission of the resolution plan is within 90 days from the insolvency commencement date. Non-approval of the resolution okay, within the 120 days, then it will be deemed to be terminated. So plan has to be submitted within 90 days and has to be accepted within 120 days. With this, we have covered the entire IBC code 2016, and this entire sheet I will ensure it's completely amended till 2025, and you will get it on our website. Okay, thank you so much guys for your patience. Clear? Is the concept clear? Yes or no? Everyone, is the concept clear? Yes or no? Have I cleared everything, the sections, etc.? And I will share this in the WhatsApp and Telegram group. So with this, I am completed with my full marathon. I've given you all the important form numbers, section numbers, run you all through the entire thing, and this sheet also I will share it with you all. Okay, with this I complete and conclude my entire marathon. Clear? Okay, great. Thank you so much guys. Don't forget to like the button, hit the like button, share a heart, do whatever you like, and inform a friend as well. So that is it. I will see you all next, and we will see you all in the next marathon. Take care guys. Good night. Have a great day. Bye.